Rodriguez. As indicated, my name is Michael Cohen. I'm an administrative law judge from the Office of Administrative Hearings, and I've been asked to preside at today's argument. Could I take the appearances of the parties, starting with the respondent?
Yes, Your Honor. Peter Osinoff, appearing on behalf of Dr. Rodriguez, who is seated beside me. Good morning.
Good morning.
Good morning, Deputy Attorney General Carolyn Westphal on behalf of complainant.
Thank you. As the parties know, the rules for these oral arguments provide that each side is provided 15 minutes for their opening argument, with the respondent going first, and then each side is allowed 5 minutes for rebuttal, again with the respondent going first. And if he chooses, the respondent can then address the board directly, although Mr. Osinoff indicates that he does not believe respondent will be doing that today. So, with that said, and I will, if you do take your full time, I will let each of you know when you have 1 minute left on your allotted time. Mr. Osinoff.
Thank you very much, Judge Cohen, and members of the panel. Here is Dr. Rodriguez. It is now almost 3 years after his DUI. He's a big guy, but he doesn't have a drinking problem. If you look around the room, few of us in this room have had less to drink than Dr. Rodriguez since the DUI in March of 2013, almost 3 years ago. He was able to testify at the time of the hearing that there were 4 occasions when he drank socially after the DUI. One at a wedding, a couple of birthdays, including his own birthday on September 6, 2014. He didn't drive on any of those occasions. Shortly after that birthday in September of 2014, he received the medical board's accusation, and as he testified, he realized that any drinking that he does could affect his medical license. He was under no compulsion at the time, but that was a shock to him, and so he stopped drinking altogether. I asked him to prove it, to prove his abstention, and he signed up with First Lab, which is the medical board's contracted laboratory for performing random drug and alcohol tests. And all of his tests have been negative. He was testing for more than 6 months before the hearing, as was a negative test earlier than that during the course of an unannounced visit by the investigators in this case. The fact is, and the evidence showed, that Dr. Rodriguez had no drinking problem except on the night of March 19, 2013. It was a very light work week. He wasn't on call. He had planned a vacation, but unfortunately his wife's mother had just died 4 days earlier after a lengthy illness, and the vacation was canceled. Dr. Rodriguez is a very big sports fan, and in Blythe, California, a little desert community by the Arizona border, high school sports are the big thing. This was a game against Blythe's high school's arch rival in a public park. The JV game preceded the varsity game, so Dr. Rodriguez spent a long time in the parking lot where they could still see the game somewhat, tailgating with his friends. He had 8 or 9 Bud Lights in about 4.5 hours. Much has been made of the blood alcohol level of 0.17 by the AG's office. No doubt Dr. Rodriguez was quite intoxicated, and as he said, he knew it that night. Unfortunately, he got into a car, and that's why the investigation started, I believe, based upon the emphasis in this case on the blood alcohol level of 0.17. So the question was, does he or does he not have a problem apart from that single instance? And we have hearings for a purpose, to decide whether Dr. Rodriguez had a problem with alcohol that might impact his fitness to practice. The hearing in this case showed otherwise. From the moment of his arrest, Dr. Rodriguez was ashamed of his conduct on March 19th. He recognized he could never again drive after drinking, and he acknowledged his poor judgment that night, and he never again drove after drinking. And then he stopped altogether when he got the medical board's accusation. He has cooperated with law enforcement from that night forward. He arose late the next morning and only went to work when he felt fine to do so. The effect of alcohol had worn off. The ALJ himself noted that it wears off at about 0.02% per hour, so he wouldn't have been under the influence at all at the time he went to work. He promptly disclosed that very day to the chief of staff at his hospital, Palo Verde Hospital, and the chief referred the matter to the Well-Being Committee. Both the then chief of staff testified and the head of the Well-Being Committee testified. They both knew him well. They knew this was an isolated incident. They were very surprised by his bad judgment that night, which was completely out of character for Dr. Rodriguez, based on their years of knowledge of him and seeing him on call at all hours. There was no report, and never had been a report from any nurses or other patients that would indicate any impairment whatsoever by Dr. Rodriguez. Dr. Rodriguez acknowledged his guilt early on. He felt terrible about this. He enrolled in the first offenders program 2 months before he pled guilty and complied with all the terms of his criminal sentence. He only drank socially before his arrest. And then, once he got the accusation, he realized he couldn't drink at all. Without any compulsion of any monitoring, he was able to stop without a problem. He testified at the hearing that he never wants to drink alcohol again. He has just as good a time with his friends, he says, at parties or sporting events as without alcohol as he did with alcohol. He has an unblemished record other than that night of March 19, 2013. No malpractice cases, no discipline, no other arrests. He is the only native of Blythe, California, who ever returned to practice medicine in that very underserved community, and it's been over 20 years now that he has served that community. There are really 3 issues in this case, and may I inquire, Judge Cohen, what my time is?
You have 8 minutes and 40 seconds left.
Thank you. The 3 issues are: can the board discipline a physician for a single DUI with no evidence of impairment or no evidence of unfitness to practice? The second issue is, if the board can, should Dr. Rodriguez be disciplined? And the third issue is, if he should be disciplined, I would ask why, but what is the appropriate penalty, if any? Now, ALJ Hewitt, Judge Hewitt, a very experienced judge, found that Dr. Rodriguez could be disciplined under Section 2239 of the Business and Professions Code as using alcohol to an extent or manner dangerous to himself or others. But he also found that there was no unfitness to practice by Dr. Rodriguez and that he couldn't be disciplined for general unprofessional conduct. The difficulty is, if there is no evidence of potential unfitness to practice medicine, then we contend that he can't be disciplined under Section 2239. All of the cases under Section 2239 that have interpreted that statute, the Griffiths case, the Watson case, have held that in order to discipline a physician, the Constitution requires a showing of a connection, and this is true of all professions, a connection between the conduct of the physician and the duties, qualifications, or functions of a physician, that is, his potential unfitness to practice. Now, the Griffiths case has been thrown at me for years, more times than I can count. I represented Dr. Griffiths and argued the case in the Court of Appeal on his behalf. I might say that Dr. Griffiths is one of the most delightful, enjoyable people, full of stories that I've ever been around, and I enjoyed his company for years after that. But he enjoyed his good wine, and in 3 times in 5 years, Dr. Griffiths was convicted of driving convictions involving the use of alcohol. The court found in the Griffiths case that the legislature had made a rational determination that 2 or more misdemeanor convictions involving the use of alcohol constituted unprofessional conduct under 2239. 2239 states that not only excessive use or in a manner dangerous to others or himself can constitute unprofessional conduct, but that 2 or more misdemeanors involving the use of alcohol involves unprofessional conduct. And for many years, a single DUI simply wasn't disciplined, simply was not disciplined by the medical board. 7 years after the Griffiths case, in 2009, the board's newsletter, and that's part of this case in Exhibit L, stated the board's position at that time that it generally would not discipline a physician for 1 DUI unless there was evidence of an alcohol or drug problem. Now, the first clause of Section 2239, the use of alcohol dangerous to self or others, had always been there, but had always been considered to apply where the physician had a problem, where there was evidence of an impairment apart from a single DUI. Thus, in the Watson case, there were 4 uses of alcohol that got the doctor into trouble. And in that case, there weren't any convictions. So the doctor argued, well, you can't convict me, you can't find I was guilty of unprofessional conduct because I was never convicted. And the court said, no, there were 4 uses of alcohol which got you into trouble. That's enough for us to conclude that you have a problem with alcohol, and we can discipline you under that clause that says you're a danger to self, or potential danger to self or others. So the medical board did not discipline single DUI cases. And then the Sulla case came along. In 2012, there was a case against a registered nurse. This is the Board of Registered Nursing case. One argument made in that case, and that involved a single DUI. One argument made in that case was that under the Equal Protection Clause, if doctors couldn't be disciplined for a single DUI, how can you discipline a nurse? And the court disposed of that argument, stating, well, 2239, which applies to physicians, had the same clause in it that we're disciplining the nurses under, and just because it has never been applied to a single DUI doesn't mean that it can't be applied to a single DUI, and therefore there's no equal protection argument. And based on that dictum, it wasn't part of the actual holding in the case, but based upon that dictum in the Sulla case, the Attorney General's office decided that this board can discipline doctors for a single DUI. Well, there's a problem statutorily because if you discipline a doctor for a single DUI, that would render the alternative clause in that statute, requiring 2 or more misdemeanors in the absence of an impairment, superfluous. That's not how statutes should be interpreted. Every clause in it should have meaning. The nursing statute did not have the 2 or more misdemeanor clause in it. And after all, what was the constitutional problem in Griffiths all about? If the argument would have been as simple as saying that a single DUI without more evidence of unfitness could be disciplined, then what's the constitutional problem of disciplining for 2 or more misdemeanors? So that raises the second question. We contend, though, that you can't constitutionally discipline Dr. Griffiths for 1.
Got a minute and a half
DUI.
left, counsel.
Minute and a half. Okay. The second question is, just because you can discipline, why do so? This is where A.L.J. Hewitt, the experienced judge, said, the purpose of discipline is only to protect the public, There's no basis for doing so here. This was an isolated occurrence. This was completely out of character for Dr. Griffiths. The public isn't endangered by for Dr. Rodriguez. The public isn't endangered by Dr. Rodriguez. Look at the steps that Dr. Rodriguez has taken since then to address what happened that night. The law rewards those who have taken steps to reform, to improve themselves. No penalty should be imposed. That was the court's position. And if a penalty should be imposed, what then? It is completely over the top and unnecessary to impose probation, as the Attorney General's office has argued. After all, the 2011 guidelines, which include discipline for 2239 violations, were rendered before anyone even thought of disciplining a physician for a single DUI case. The uniform standards for substance abusing licensees, which are argued in this case by the Attorney General's office, aren't applicable where there's no evidence of a substance abuse disorder, as here. So this case, without any history of any other problem, and with a single DUI, and with the steps taken by Dr. Rodriguez, bears no evidence that there should be any reason to penalize Dr. Griffiths in order to protect the public. No basis for public protection exists in this case. Thank you very much.
Thank you. Are there any questions for Mr. Osinoff from the panel members? Hearing none, Ms. Westphal.
Thank you. Ladies and gentlemen, the facts of this case are relatively undisputed. We know Dr. Rodriguez was arrested for a DUI back in 2013, and he later suffered a conviction for that. Through his own admission, he drank at least 9 beers on a weeknight after he worked when he knew he had to be at work the very next morning. Despite drinking that excessive amount of alcohol, he then felt intoxicated and chose to disregard the law and get in his car and drive, placing himself and others at risk. When he drove himself home, he ran a red light without stopping. And when he was arrested by an officer, his blood alcohol level was tested over an hour after driving, and it registered a 0.17, well over twice the legal limit, considering the fact that the ALJ pointed out 0.02% leaves your body every hour. And then he does, in fact, report to work less than 9 hours later, beginning to treat patients. We don't agree necessarily that he has proven he has no drinking problem. Counsel points out that much has been made of the blood alcohol level, and it is important to note that Dr. Rodriguez was able to drive his vehicle without too much problem with that high level of alcohol in his system. That is indicative of a regular drinker. So 9 beers in his system is a conservative estimate, but we'll give him the benefit of the doubt. So the first question, as counsel pointed out, is can the board even discipline a physician for a single DUI? Counsel argued this point at the hearing, and it was rejected by the ALJ. It was rejected because it was also rejected by the Court of Appeal in Watson v. Superior Court. This issue has been argued and argued and argued again. One need only read the Watson case, the bulk of the Watson case, to understand that the court has made painfully clear that 2239 allows various theories within it, various conduct that is deemed unprofessional conduct. And where the legislature has specified what is unprofessional conduct, the legislator has declared it's substantially related to the practice of medicine. No other proof is necessary. The board may discipline for excessive use of alcohol, dangerous to self or others. And because this issue has been decided by the Court of Appeal, I don't wish to waste any more of the board's time on this. So the next question is, should the board exercise its discretion in disciplining Dr. Rodriguez in this case? Counsel relies on a 7-year-old newsletter by the former chief of enforcement of the board, as well as his assumptions about what types of cases come to the Attorney General's office and what types of cases get filed on. He also argued in his papers that even the most egregious of DUIs only get public reprimands. What other DUIs, how other DUIs are penalized based on their specific facts is not relevant. Each case is taken on its own. And counsel's argument about what the board may or may not have done and what the AG's office may or may not have done is unfounded, unsupported, and quite frankly, it's outdated. We all know this is a new day in the light of the uniform standards that say that when a physician has been charged with an unprofessional conduct involving abuse of alcohol or drugs, they are presumed to have a problem. The fact that the uniform standards are in effect at all speaks to the fact that whatever had been done in the past wasn't achieving adequate public protection, and more oversight was necessary by the board. DUIs matter today. They are serious. Common sense tells us that they are extremely dangerous. But the reasons discipline is appropriate for this particular DUI is perfectly articulated in the Griffiths case that counsel referenced. The court in Griffiths discusses DUIs very specifically, saying convictions involving alcohol consumption reflect a lack of sound professional and personal judgment. They show a disregard of the physician's medical knowledge concerning the effects of alcohol on vision, reaction time, motor skills, judgment, coordination, and memory. They show an inability or an unwillingness to obey the law. They constitute a serious breach of duty to society, and they place themselves at risk. They also reflect a personal problem involving alcohol consumption. For all of these reasons, the board need not just sit back and wait until this particular physician's poor judgment and potential alcohol problem interferes with his medical practice and patient care. The board should impose some discipline necessary to protect the public from potential future harm. The board can discipline, the board should discipline in this case. So what level of discipline is appropriate? Well, when determining what level of discipline is appropriate, I think the board should look to its own guidelines. The guidelines themselves that have been adopted to further public protection. The guidelines themselves that list out with specificity for each violation what terms are recommended. And for the violations for which Dr. Rodriguez has been found, specifically state in the guidelines, 5 years probation. 5 years is the starting point. The guidelines should be followed not just because in and of themselves by disciplining a doctor it furthers public protection, but they allow for uniformity. They allow for deterrence, and that furthers public protection, which is the only reason to discipline anyone to begin with. Of course, the guidelines can be deviated from if there's evidence of mitigation and rehabilitation. And counsel has argued, as he did at the hearing, that no discipline is necessary because his client has provided some evidence of rehabilitation. It's true. His friends came in and said he's a good guy. We don't know he has an alcohol problem. He's a good doctor. It is true he provided 6 months' worth of biological fluid testing that said he had stopped drinking in the months leading up to his hearing. The evidence that he's shown of any rehabilitation and mitigation, however, how on earth does that justify a deviation from 5 years down to 0? Such a giant leap down to 0. And he argues that, well, this was just an isolated event. How do we know this is an isolated event? What do we know about this event? We know 9 beers. 9 beers, a 6-pack and a half in one sitting on a work night. Who does that? It is unlikely that he is the unluckiest person in the world. On the one night he does that, he gets caught. The best indicator of future conduct is past conduct. So what do we think he's going to do in the future? Well, most people do the same things over and over again. Maybe he means it when he says he's learned his lesson. Maybe he means it when this has gotten his attention. Though risking any discipline with his license was insufficient to get his attention back in 2013. But somehow this has gotten his attention. So let's hope he means it. But the board has to be concerned. And when the board is concerned, the best thing the board can do is just have some oversight. Let's make sure this doesn't happen again. Let's make sure he doesn't have an alcohol problem. Let's make sure this series of poor decisions he made that night don't continue to affect his personal life and then interfere with his medical practice if it hasn't already. It is always better to implement discipline before harm occurs, and for that reason, we're asking for some level of probation consistent with the disciplinary guidelines. Thank you.
Thank you. Do the panel members have any questions for Ms. Westphal? Seeing none, Mr. Osinoff, you now have 5 minutes for your rebuttal argument.
Thank you, Your Honor. Dr. Rodriguez never denied that he did wrong that night. He admitted that from the start, and that it was bad judgment that night. He was not on call. He was not working that night. But he shouldn't have done what he did. It was a crime. He's acknowledged that. But that doesn't mean that you need to discipline if there is no public protection purpose in doing so in this case, and that's exactly what Judge Hewitt found. There was no proof of any drinking problem in this case, and there is no presumption. The law does not make a presumption of a problem or presumption that Dr. Rodriguez has a problem. This is not a case under the substance abusing licensees, new uniform standard for substance abusing licensees. Those aren't applicable to the facts of this case. There are many DUIs, single DUI cases that have been investigated, and many single DUI cases reported to the board where no action is taken whatsoever. Just because this case went to a hearing and had a full hearing on the matter, and just because the board's investigation did not reveal any other evidence of a problem other than that night, and the testimony of the witnesses was found credible by an experienced administrative law judge, doesn't mean that just because this case went to a hearing that we have to punish this single DUI case. Others that have gone to a hearing for single DUI cases without evidence of a impairment have resulted in public reprimands. Generally two or more DUIs does result in probation. We don't have that here. The purpose of the investigation by the board is to uncover evidence of an impairment other than this single DUI. There was none. As Ms. Westphal said, the best indicator of future conduct is past conduct. We look at what Dr. Rodriguez has done in his past conduct. Absolutely nothing to indicate that he has any problem. The chief of staff said that 99-point-something% of the time I would hear about a problem if a physician had one, and he did not hear of one. People on call, people who called him in the middle of the night to assist them at C-sections, for patients who were in the ER in the middle of the night, never encountered any problem with Dr. Rodriguez. This is now more than 20 years of practice there without any other problem. So just because, assuming hypothetically that my legal arguments are wrong on the constitutionality issue, whether you could discipline for a single DUI, putting that aside, just because you can do it doesn't mean that you have to do it unless there is a public protection purpose in doing so. Not just a knee-jerk reaction, while we have a single conviction, then we're going to say, well, maybe it'll happen again, or maybe he'll endanger the public. That doesn't exist. That exists less with this physician than most other physicians in the state who haven't had convictions. So there is no reason on the basis of this single conviction to discipline Dr. Rodriguez, to protect the public. There is no protection of the public purpose exists in this case for that. Probation is simply way over the top and completely unnecessary in a case of this type. And thank you very much.
Thank you. Ms. Westphal, you have 5 minutes.
Thank you. A dismissal in this case would entirely defeat public protection, and it would do nothing to aid in Dr. Rodriguez's rehabilitation or even continued rehabilitation, giving him the benefit of the doubt. Yeah, there's no truer indication of rehabilitation than sustained conduct over a period of time. That's what we need. We need time. Time and oversight. Let's take a look just to be sure. Probation is absolutely necessary because Dr. Rodriguez needs time. Thank you.
All right, thank you very much. Mr. Osinoff, again, I'll ask if Dr. Rodriguez wishes to take some time to address the board directly.
No, but if the panel has any questions for me or Dr. Rodriguez, I would welcome that.
I see no hands, so the answer is no.
Thank you very much.
So this matter will now stand submitted. The record is closed. The panel, will now adjourn to executive session.
The time right now is 12:45 p.m. I'm Dr. Felix Yip, Chair of the committee. I would like to ask all of us to please turn our cell phones to silent, and for the board members, please make sure they're off the table so we can avoid feedback noises. You may notice board members access the laptop during the meeting. They are using the laptop solely to access the board meeting materials that are in electronic format. This is an official business meeting of the Medical Board of California. As such, disruption of the board's business will not be tolerated. We have Kara on my side to enforce that. We have a designated time on the agenda for public comment, and we will be asking for public comment on each agenda items. I ask that you be respectful of the need to conduct the board's business. Should anyone disrupt the meeting, I will ask the person to conduct himself or herself in such a manner that permits the board to transact its business. The board welcomes public comment on any item on the agenda, and it is the board's intent to ask for public comment prior to the board taking action on any agenda item. If for some reason I forgot to ask for public comment on an agenda item and you wish to speak on that item, please raise your hand and you'll be recognized. I would like to request all speakers to complete a presenter slip so I can call you by name at the appropriate time, and the record of this meeting can be full and complete. However, this is voluntary. Please give the speaker slip to Ms. Chu. Ms. Chu is right here. This meeting will be available via teleconference. Individuals listening to the meeting will have an opportunity to provide public comment and will be assisted by a moderator who will be facilitating the teleconferencing process. For those members of the public participating via the teleconference, please wait until the moderator has introduced you before you make your comments. To request to make a comment during the public comment period, press star 1. You will hear a tone indicating you are in the queue for comment. If you change your mind and do not want to make a comment, press the pound sign. Please remember to mute the volume on your screen to avoid feedback noises. Assistance available through the teleconference meeting. To request a specialist, press star 0. Each person will be limited to 3 minutes per agenda item. However, during agenda item 2, public comments on items not agenda, the board has limited the public comment period for individuals on the telephone conference and those present here today to 20 minutes. Therefore, after 20 minutes, no further comments will be accepted. During public comment on any other agenda items, 10 minutes will be allowed to comments from the individuals on the teleconference line and those in the audience. After 10 minutes, no further comments will be accepted. Staff from the board's business service office will be assisting me with receiving the public comments via telephone conference during this meeting. I would like to remind all speakers to please stay on topic and keep your comments to 3 minutes or less. I would like to call this meeting to order and have Ms. Chu please call the roll.
Dr. Bolat?
Here.
Dr. Kraus?
Present.
Ms. Yaroslavsky?
Present.
And Dr. Yip.
Present. Thank you. A quorum is present. I would like to remind the members that we will be taking a roll call vote on all action items. Let's move to item number 3, public comments on items not on agenda. I do not see any speaker slips for the items not on agenda. Are there any comments on the phone? If yes, please limit your comments to 3 minutes.
It's on the phone.
No? Okay. Well, let's move on to our next
No comment
agenda.
on the phone.
Is one? No? Okay. So let's move on to item number 3, approval of minutes from October 29, 2015 meeting.
So moved.
Are there any public comments from those in the audience? Any comments from those on the phone?
Do we have any comments on the phone?
No, there are no comments.
Thank you. Ms. Tu, please take the call.
Dr. Bolat?
Here.
Dr. Kraus?
Yes.
Thank you. Ms. Yaroslavsky?
Yes.
And Dr. Yip?
Yes. So minutes approved. We now move to agenda item number 4. Ms. Delp, please provide an enforcement program update.
Thank you, Dr. Yip, and good afternoon, board members. The expert reviewer training is scheduled to take place on Saturday, March 19, 2016 at the UC San Diego School of Medicine. The full day of training will include welcome remarks from Executive Director Kim Kirchmeier and Enforcement Committee Chair Dr. Felix Yip. Also on the agenda will be an overview of the expert program's mission and expectations, legal considerations when opining on a case, a rundown of different case scenarios, and segments on testifying provided by the perspective of a retired administrative law judge, a deputy attorney general, and a defense counsel. The training will end with a review of a mock case, and attendees will be asked to provide a written opinion regarding whether the physician departed from the standard practice of medicine. Board staff will review the opinions, and feedback will be provided to the attendees. Last Friday, a save-the-date announcement regarding the training was emailed and mailed to experts in the San Diego area and surrounding territories, and already the board has received interest to attend from several physicians. A formal invitation to attend the training will be sent out within the next couple of weeks, and additionally, staff is looking into the possibility of conducting a second training this summer in Southern California and training this fall in Northern California. Training with the Office of Administrative Hearings will begin this month. On January 29th, the administrative law judges will receive training on anatomy and systems of the body. Lining up additional trainers has been challenging. Conflicts arise when the days the instructors are available are not in sync with the days the Office of Administrative Hearings has set aside for the training. Nonetheless, the board's efforts will continue, and I may reach out to board members to assist me in identifying a speaker to provide some of the training. On January 5, 2015, Enforcement Committee Chair Dr. Yip spent the entire day with management and staff from the Northern Probation Office discussing how the probation unit operates. Dr. Yip reviewed the daily functions performed by staff and the methods used to monitor a licensee's compliance with the terms and conditions of his or her probation. The meeting was very productive, and some new policies and procedures to streamline and improve the probation monitoring process will be implemented. Later on in the Enforcement Committee meeting, I will provide a presentation to the committee members about the probation unit's roles and functions. At the October board meeting, I mentioned an issue raised by the Office of the Attorney General regarding the use of the same investigator that works a complaint both criminally and administratively. On December 8, 2015, Executive Director Kim Kirchmeier, Ms. Webb, the board staff counsel, and I met with executive and legal staff from the Department of Consumer Affairs, staff from the department's Health Quality Investigation Unit, and staff from the Office of the Attorney General to explore this issue. The discussions were enlightening to all that attended, and the meeting adjourned with an agreement that staffs from the Attorney General's Office and the Health Quality Investigation Unit would resume discussions at a later date with hopes of drafting a policy to be considered by the Department of Consumer Affairs. On a separate note, the board took measures to mitigate a concern raised by the Attorney General's Office that complaints being investigated for criminal prosecution are not being tracked effectively. As such, by not having a process to track the cases, the issue could adversely impact the board in being able to file timely administrative actions when a district attorney's office rejects the filing of a criminal case. To solve this concern, the board identified a staff person who is now actively monitoring the caseload. Lastly, Enforcement Program Manager Paulette Romero and Enforcement Unit Managers Charlene Smith, Ramona Carrasco, and Brian Curtis have been working diligently to evaluate the complaint handling process to find ways to improve the amount of time it takes to process a complaint. I commend their efforts and want to publicly thank them for developing a plan to adjust caseloads and reorganize the Central Complaint Unit's reporting structure. By adjusting the caseloads, the complaints will be more evenly distributed among staff, thus decreasing overall complaint processing timeframes, and with reorganizing the reporting structure, managers will have fewer staff to supervise, affording each manager with more time to coach and mentor their staff to ensure they have the proper training and tools necessary to process complaints effectively. The proposal will be submitted to the Department of Consumer Affairs for approval, and once approved, the plan will be implemented. This concludes my enforcement update.
Thank you. Are there any questions, comments from the board members? Any public comments from those in the audience? Any comments from those on the phone?
Do we have comments on the phone?
No comments from the phones.
Great, thanks. Move to agenda item number 5. Ms. Robinson will now provide an update on the demographic study.
Good afternoon, Chair and members. At the last Enforcement Committee meeting in October, I provided information on the board's demographic study that is being conducted by the California Research Bureau. I'm happy to provide an update on the progress of the study. On December 20th, the Bureau met with interested parties that included Dr. Jackson and Dr. Savage, Minister and Co-Minister of Health for the Black American Political Association of California, and Dr. Lang, President of the Golden State Medical Association. This 2-hour meeting covered 10 items of concern, including the impetus behind the study. There may be additional information the Bureau needs to obtain from the board to review based upon this meeting, but that will be determined by the Bureau. Further, the Bureau confirmed that the report will be released to the public. Next, the Bureau will finalize the research design and methodology, then provide this information to Dr. Kraus for review and approval, as approved by this board when requesting this report. The Bureau has anticipated that it will take approximately 2 months to finish the analysis and an additional 2 months to finalize the report. I will continue to monitor the progress of this study and give updates accordingly. This concludes my update on the demographic study.
Thank you. Any questions, comments from the members? From the audience? Any comments from the phones?
Any comments from the phone?
No commenters from the phones.
Thanks. So move to agenda item 6. Ms. Robinson and Ms. Curry will now provide vertical enforcement report update.
As is required by law, the board has been working with the Department of Justice and the Department of Consumer Affairs to report and make recommendations to the legislature on the vertical enforcement model known as VE. VE initially began as a 2-year pilot program that was implemented in January 2006. The goal of VE is to bring investigators and deputy attorneys general together from the beginning of an investigation with the goal of increasing public protection by improving coordination and teamwork, increasing efficiency, and reducing investigation timeframes. Over the past 10 years, the board has provided 4 reports to the legislature on VE. The most recent report was included in the board's supplemental Sunset Review Report 2013, which is available on the board's website. In October, Ms. Anita Scurry and I began working on the most recent report due to the legislature by March 1st. The board's IT department has been working diligently to provide us with fiscal year 2013-14 and fiscal year 2014-15 statistical data needed to complete this report. The task has been a challenge due to the need to rewrite the report request for the language now contained in the new Breeze system. Once we receive the data, we will finalize the report and provide a draft copy to the Department of Justice, the Department of Consumer Affairs, Dr. Yip, and one other board member of Dr. Yip's choosing to review the report. We plan to bring the final report to the board in a special meeting by the end of February to meet our March deadline. This meeting may be held by teleconference. I will now turn it over to Ms. Scurry to discuss what she has been working on. Thank you.
For those of you who don't know me, my name is Anita Scurry. I was a supervising senior staff attorney with the Department of Consumer Affairs, and I provided representation to the board, the medical board, for 19 years in that capacity. And I also worked on the development of the new VE protocol after the board's investigators were moved from the medical board to the department. And I was asked to assist in preparing this report. We expect that our report will consist of 3 primary areas: the statistical data mentioned by Ms. Robinson, which we've been trying to get for a time, but it's trying to get apples and apples from 2 different data systems has not been easy. We also are going to talk about improvements that have taken place since the last report in 2013 and some recommendations for statutory changes. That's the primary focus. We have been working with the Office of the Attorney General as we have been preparing this report. Are there any questions?
Questions from the member? Any comments from the audience? Comments from those on the phones?
Do we have any comments on the phone?
Okay, great. Thank you.
No comments.
We're looking forward to your report before the end of February. Okay. So moving on, agenda item number 7, Investigation and Vertical Enforcement Program Report. Ms. Chris and Ms. Nichols will provide a program update from Health Quality Investigation Unit. And Ms. Castro will follow with a program update from Health Quality Enforcement Section. And please.
Good afternoon. My name is David Chris. I am the new chief of the Division of Investigation for the department. Michael Gomez retired in December. I wanted to introduce myself today and tell you a little bit about my history. Previously to being selected as chief, I served as deputy chief of the division since 2012. I've also served in various investigative and managerial law enforcement positions in the past, including Deputy Inspector General Senior for the Office of the Inspector General, supervising investigator for the Investigation and Services Team, which is the Internal Affairs Unit for the department. And prior to working for the state of California, I worked as a police officer, a police corporal, and a police sergeant. What makes me truly unique is that I was also an investigator for the Medical Board of California in Los Angeles. And since the new year, I've been working with Kathleen Nichols to get up to date with things at HQIU. Currently, I plan to focus my efforts on filling our vacant positions, continuing the staff retention projects, the salary package, and field training officer pay, and continuing the strategic planning process, completing the combined DFI policy training manual, and developing a division-wide training plan. And then referencing our vacant positions, currently we have 26 vacant positions and 21 people in background for those positions, so we're making good progress there. And we have interviews scheduled to fill those remaining positions. And then additionally, we had some statistics and information that Kathleen is going to present.
Yes, at the last board meeting, a question came up about how we are prioritizing our cases for the board. So I just wanted to talk briefly about that. There's actually a Business and Profession Code section that mandates what the board's priorities are, and that information is in your packet. I won't read it verbatim, but to go over it briefly, it's section 2220.05. So the priorities are cases that involve gross negligence, incompetence, or repeated negligent acts that involve death or serious bodily injury to one or more patients. Cases that involve drug or alcohol abuse by a patient and surgeon involving death or serious bodily injury to a patient, repeated acts of clearly excessive prescribing or prescribing without a good faith exam. An additional one that was added per the statute as of January is repeated acts of clearly excessive recommending of cannabis to patients without a good faith exam, sexual misconduct, and practicing medicine while under the influence of drugs or alcohol. So what we have done is we have gone through an entire list of cases, identified which cases are priorities and which cases are lower priorities. Anything on this list has been deemed a lower priority case. Anything on this list is a priority. And how we're splitting our time is that we're spending 4 out of the 5 days a week, or 32 hours a week, working priority cases, 8 hours a week working lower priority cases, and then those cases will be rotated so that work will be completed on every case. But we're very focused on protecting the public and keeping the priority system that's already been established. And that concludes our report.
Any questions, comments from the board members? Any public comments from those in the audience? Any comments from those on the phones?
Do we have any comments on the phone?
Okay,
No
great.
comments.
No comments?
Can
Great.
I just ask a point of information? Are we going to get regular reports back on your achieving those kinds of goals so that we will be able to monitor and know that, in fact, it's working? That you're...
Yes, and I believe there were some statistical graphs in your packet about cases over a year old and cases over 550 days old, and we will continue to produce those for you.
Okay, because we're starting to see more cases that were older than newer, or I'm starting to notice, and I'm
Correct.
just concerned.
I think some of that has to do with the vacancies, and also as you're prioritizing, if you're working, spending the bulk of your time as it should be on priority cases, some of those lower priority cases, we might see those numbers actually increase. But right now, this is all about, prioritization, protecting the public, and that's where we're at.
Okay, thank you.
It's one of those things that I work with the staff, hopefully provide like an aging report to report to the board. So.
Thank you.
Moving to agenda item number 8, Ms. Dell will provide a presentation on the probation unit's roles and functions. You change? Oh, Ms. Castro.
Actually,
Thank
I
you.
know I'm next, so that's why I'm up here.
Actually, you will be next.
Yes. And I'm going to have Mr. Bell sit here. Thank you. Good afternoon, Gloria Castro, Senior Assistant of Health Quality Enforcement Section. I come before you today to describe the status of the Vertical Enforcement Program, currently under the auspices of the Attorney General's Office and the DCA Division of Investigation Health Quality Investigation Unit. I have been the Attorney General's Health Quality Enforcement Section since 2004. I've been the Senior Assistant since April of 2012. I'm very familiar with the history of the VE program and with its implementation, especially since July 2014, when DCA assumed the investigative duties for medical board investigations. Additionally, a significant percentage of my senior HQE staff have 20+ years experience in this section. They were here when the section was created in 1990. To my left, I have Supervising Deputy Attorney General Terry Jones, and in my back here, we have Supervising Deputy Attorney General Robert Bell. The goal of the Vertical Enforcement Program is to efficiently investigate allegations of unprofessional conduct, to close meritorious cases, and to prosecute worthy cases in a timely manner, in order, in the language of one court, to, quote, protect life, health, and welfare of the people at large, and to set up a plan whereby those who practice medicine will have the qualifications which will prevent, as far as possible, the evils which could result from ignorance or incompetency or lack of honesty and integrity. Two issues are adversely affecting the Vertical Enforcement Program. First is obviously the continuing issue of staffing investigative positions within HQIU. This problem existed before the transfer of investigators to HQIU and continues now to a higher degree. The turnover of investigators leads to the reassignment of investigations to new investigators who, despite undergoing training, are unfamiliar with the nuances of the Vertical Enforcement Program. And because of the unfilled vacancies, which at times have gone up to almost 30%, the remaining investigators strain valiantly yet unsuccessfully to keep up with their expanded caseloads. This adversely affects the ability of the Attorney General's office and her cadre of experienced Deputy Attorney Generals to effectively direct investigations and the ability of HQIU to timely and expeditiously complete investigations, thereby drastically delaying public protection. In large measure, it is not until the administrative process is completed that public protection kicks in, and this is when we put the public on notice. And in the words of one court, that when we reach the administrative process, and that is with the filing of an accusation or the filing of an ISO, interim suspension order, That is when the public ends up finding out the unqualified and undesirable persons and those guilty of unprofessional conduct in the medical profession, which is a very small percentage, but very important to put the public on notice. So obviously the delays due to the lack of investigators means achieving the board's public protection mission is delayed. The second issue adversely affecting the vertical enforcement program is the policy of HQIU handling administrative investigations as criminal investigations, and it takes those matters out of the vertical enforcement program, which was established by the legislature as the best means to achieve protection of the public from unprofessional physicians and surgeons. Once a case is being investigated criminally, due process considerations prohibit the use of administrative investigative tools for the criminal investigation. And I know it's a very highly technical expression here that I'm trying to make, but there really truly is supposed to be a dual parallel proceeding. And as you heard from Ms. Nichols, we are working on it, and Ms. Delp also described where we are with that. However, the cases keep coming in, and we still have to move forward to protect the public. So for now, cases within the board's central complaint unit are being referred to HQIU for administrative investigations under the VE program, under the direction of the Attorney General's office, but some are being diverted into criminal investigations by HQIU under the nominal direction of district attorneys' offices. Many, if not most of these cases, though worked up criminally, are not being accepted for criminal prosecution by district attorneys, and for valid reasons. These are very highly complex cases, and sometimes the expertise is not there. After a failed criminal investigation does not end up in a criminal filing, what ends up with happening to the case is that that case is presented to the Attorney General's office as a handoff case to be administratively prosecuted. And those cases of which we had to come out of because they became criminal have had none of the input required by the legislature when it created the vertical enforcement program. For these cases, and they're minimal for now, but that's why I'm bringing this to your attention at this juncture. For these cases, that handoff is actually a discredited method that was discredited 10 years ago when the VE program was created. The whole process, again, leads to delays in achieving public protection, usually on the most important cases. It wouldn't be classified as a criminal case if there were not very important considerations to it. And those are also ISO cases in many respects. Additional investigative efforts are sometimes necessary on these handoff cases, thereby increasing the time delay. And this includes trying to interview a subject that now is aware that maybe a search warrant was served on his premises and therefore has no reason to speak to us, and establishing a chain of custody for medical records obtained by search warrant. So there are things that we could overcome, but there are delays associated with those things, and we have a clear and convincing standard of evidence that we need to achieve in order to file your important cases. So this interferes and perhaps denies the ability of the Attorney General's office to seek an ISO to protect the public in an expeditious manner. It is uncertain to me how many cases are being handled by HQIU as criminal investigations. We've requested this information, and you've heard about the challenges with respect to Breeze, and I don't know if that's what's affecting it. But in my estimation, this could be as few as 60 cases to as many as 200. I don't know. One solution to this quandary is fairly simple. We have to assign a second investigator to investigate the administrative investigation. Now, you've heard about the priorities that you have as the medical board under statute. Those priorities do not speak of your ability to file criminal cases. They truly only discuss disciplinary. And I know that DCA's mission and goals is criminal. That is part of their priority. So I think that a conversation should probably occur between the medical board and HQIU to make sure that those priorities truly match and what to do when they're not truly matched. And I'm only discussing the parallel investigations where criminal and civil issues come up on the same subject. In order to ensure compliance with the legislature's mandate to use the vertical prosecution regime to achieve public protection more expeditiously, The solution would be, and especially in light of the staffing issues, to permit the Attorney General's office to provide limited investigative services to the medical board to address this issue in the interim while a parallel proceedings policy is put into place and while you have that conversation and while all these issues are resolved between those two parties. This would permit the completion of civil investigations on a timely basis, and we would be able to provide some of that assistance from the Attorney General's office. The funds that would otherwise be used by the medical board to pay for the salaries of currently vacant investigator positions could be used for this purpose, but it's even more simpler than that. Traditionally, on average, our health quality enforcement section leaves unexpended about $1 million on average per fiscal year of its legal funds that you encumber for the use of our attorneys to prosecute your cases. This would be captured under a billing rate. And that could be another solution in the interim to bridge the gap between the priorities at play here, which are all important, the criminal and the civil, but which, for public safety's sake, would be prudent to achieve on a fairly consistent basis to avoid handoffs of any cases that are old and where the public has not been on notice because we've been waiting for a criminal investigation to move forward. And this type of solution would be available on ISO matters, which are very important to this board, as we've heard in the last board meetings. And it would comply with the statute that the Attorney General directs civil investigations of disciplinary actions. It would help the board comply with its ethical obligations in criminal proceedings. And it would resolve, obviously, the most important issue, which brings us here every 3 months, which is to protect the public and patients from visiting physicians that we know to be dangerous. And that concludes my report.
Thank you.
Thank you.
I'll defer to Dr. Krause first.
Thank you very much.
Thanks.
I'm interested to know from the Attorney General's point of view how our expert panel system is. Is it adequate? Is it broad enough? What do you see as the strengths and weaknesses or any improvements that may need to be made?
That's an excellent question, Dr. Krause. There's a continuing and debilitating effect, I think, by the expert reviewer program. I think the staff here tries their best. I think we have some great physicians out there that want to do the pro bono work, but we still have limitations. And that issue cannot be overstated as having a direct impact on our ability to do what we can to protect the public. Training is part of it. I think a lot of you could do a lot of good in going out there and telling people the importance of your role as a physician to elevate the quality of the profession at large. And also not just to elevate the profession, but to also, it works two ways, Dr. Krause. It works in the way that we file meritorious cases, but don't forget, we also don't file unmeritorious cases. And ultimately, yes, our success rises and falls on the words of our experts. And it is for this reason that the quality and soundness of expert opinions submitted to the Health Quality Enforcement Section in quality of care cases is just so very, very important. And the fair prosecution of the cases and the filing of only the most meritorious are of the utmost importance to the Attorney General.
Follow-up is, in your view, is there a adequate ongoing dialogue between the medical board staff and the AG's office regarding where the holes and weaknesses are so that we can work on improving that?
I'll let you answer it. Conversations that happen.
Well, the principal interaction between the medical board, it's more between HQIU and the medical consultants in the field in the selection of physicians as experts. That's where the rubber meets the road, so to speak. There's a limited pool from which to draw. And the actors in that interchange really don't have the ability, as I see it, to try to expand the pool of experts. I think that is something that has to be at a higher level, and I think what Ms. Castro was suggesting is perhaps the board could use its voice and authority to raise the call to members of the profession to step forward and to engage in this peer review process more.
Thank you. I know that the medical board is continuing to work on that on a daily basis, but I'm wondering if there's a mechanism when the AG's office reviews a case and sees that a case cannot go forward because the expert opinion is not strong or not appropriate, or there are differing expert opinions, or there's no availability of a qualified expert, if that specific information comes back to the board in some way that it can be tabulated so that we know specifically where the greatest weaknesses are.
There is a mechanism, there is a report that we attempt to file each of the DAGs on a case, have access to this form, which is forwarded to the medical board to grade the expert in a particular case. You're sort of mixing a couple of issues in your question. If you have a case, it goes out to a couple experts and they disagree on what's what, that means we're not going to prosecute that case. But what it means is there isn't sufficient evidence to show a violation, so we have to conclude that there wasn't unprofessional conduct, and that professional gets to move on and hopefully continue practicing using best practices. So that's not a defect of the system. That's actually what it's supposed to be doing. It's when we do have two experts that do agree and we file a case and then we go to hearing, that's where we sometimes run into difficulties. The defense counsel will spend more money and get an expert with a thicker CV, and issues in the hearing come down to credibility between what our experts are saying and what the defense experts say. So if we can increase the credibility of our experts, that will have a beneficial effect on achieving discipline through the administrative hearing process.
And we spend a lot of time on this topic, Dr. Kraus, because I think that the deputies that handle these cases are definitely expected to treat the experts assigned to their cases with the utmost care so that they return and have a good experience. And I'm going to say that, if we go to hearing, there is a battle of the experts, and sometimes even great experts that do a fantastic job beg off the next time because it is a very adversarial process. However, I will submit that if it's an adversarial process and the right decision is the outcome, truly the community standard of care was argued between experts in a forum, which is this, that ultimately does the right decision every time, or at least what feels like the right decision under the circumstances.
I would defer to Ms. Kirchmeier first.
Dr. Yip, I'd just like to actually address some of Dr. Kraus's questions as well from the medical board side. In regards to us finding out if there are holes in our expert pool, that's something that we have one's vacant, but two AGPAs, which is an Associate Governmental Program Analyst, that are in Southern California that really are the two individuals that run this program working with Ms. Delp. And so those individuals are always on the lookout for areas, and it comes from, I believe, both the Attorney General's office letting us know where they see holes, as well as from Health Quality Investigative Unit that lets us know we're really lacking in this area. And then in the full board packet, I believe it's under 6B, the Enforcement Program Summary, that report there identifies where we have need of individuals. We also use that information to put in newsletter articles where specifically what fields we're missing those individuals in, so we can get that information out to them to the licensees so they can assist where necessary. So we do have that interaction, as well as the Attorney General's office, as well as HQIU do evaluations on the experts, provide those to the board, and then that goes into our database. In regards to recruitment, part of the reason we actually got another AGPA when that position is filled again is to do recruitment, and that is our plan after we get our training. We think the training, because we haven't done training since the end of 2013, we think training is the most important aspect of that right now, which is why we're planning the March one. But we will be doing recruitment, and those individuals are going to be prepared to be able to go out to hospitals during ground rounds or different things that are happening out in the hospitals where they can go and make a presentation and try to recruit those individuals. And lastly but not leastly, one of the board members has actually talked to us about maybe reaching out to the UCs to try to get experts, because that would be a good pool. Those individuals are really busy, but that is a good pool where we could pull experts from as well. So I just wanted to address that.
So I just have a couple of questions. My concern is that it seems that every meeting we hear about staffing issues that are causing holes in the time frame, that investigators being in the wrong place with the wrong entity causing time delays. And my concern is that now that we don't have control over those investigators anymore, that it's no longer a two-person VE program, it's almost like a three-person, three-legged stool. And what I'm hearing is maybe we should go to a four-legged stool. So the more legs we're putting on the stool, we're not getting a situation where we're going to have better outcomes. We're having a situation where we're going to have less outcomes. So I'm not so sure that on a go-forward basis that there isn't some other kind of model that the AG's office should be helping us with. And that might be cross-training. That might be within different departments working on the same materials. But I'm going to tell you honestly, you're not Mr. Gomez anymore, but trust me, Mr. Gomez has heard from me before. And the frustration is that I understand that more cases are coming forward, that more people are doing things that need to be investigated, that less people are working in the state, making less money, having not enough time to do the job. But there has to be a way to make the system work. And if you guys are not going to be able to handle the investigators to do the work, and then we're going to have another group, it's starting to feel like to me that it's the same old record. Now, you guys are lucky because you have new board members who have not heard my comments before. And you've got new people, not so new in the audience, that have heard my stories before. But after a while, the buck's got to stop with us. And the timelines and the time frames and the cases and the expert witnesses that don't agree and the people that don't show up to do testimony, it's an excuse. So instead of figuring out what excuse can we tell this week or this quarter, how about if we try and sit down and figure out how to make the system work?
Yeah. And if I could respond to that, actually,
Sure.
We've had a meeting with the AG's office and the department and HQIU and the medical board to address these very issues, and the issue of the administrative and the criminal investigations. We did do some research on how many criminal cases are out there. It's less than 100. I believe it's around 75. We don't have that exact data, but we will get that for you. And, I've even had ongoing discussions with the Attorney General's office that we're going to be meeting in the future. And part of this discussion that we had less than a month ago was to develop guidelines on how to make this happen now, currently, with the investigators that we do have. And in that meeting, I think it was a very positive meeting. And the suggestion was, by the Attorney General's office and us, was to work together jointly to develop these guidelines, and we do have a draft and are going to be meeting to correct this problem and ensure that the public is protected.
I look forward to seeing this happen because it's frustrating. It's frustrating then when medical board members are reading cases because it was a criminal case that took place 5 and 8 and 10 years ago, and the doctor's still not being disciplined or is now being disciplined so much later, and they've been practicing all along, and now we're looking to put retroactively for what's being, it's just the system is not functioning. So somehow it's got to be that either you have more teeth or you have more teeth. I've got an awful lot of teeth. I'm getting, it's frustrating.
And it is frustrating, and I think we're making progress. I mean, it seemed to be a little bit one-sided, but it is not. We are working together to try and resolve the problem.
So make sure that when you come before us, in the future that you're giving us this information so that we hear it and the public hears it, and it's not that it's happening between your meetings in some off-site location because you guys are working together. We need to hear more about what's making the train run on time, okay?
Yes, thank you.
Yes, thank you. And I want to just echo what I heard from our medical board, from Ms. Kirchmeier, as a former reviewer. I will tell you it is extraordinarily important to have the appropriate education and training. It is not easy to apply the law when you're not a lawyer. And it's equally hard is when you don't understand it's not just about how you practice, but not to compare one's own practice. I think that the training that's going to be required needs to be put forth between all the agencies, because every case I know that I did, it does take time, expertise, and knowledge that has to be shared amongst all of you. Otherwise, I think it's very hard to take a doctor. He or she may have great technical knowledge, but he or she needs to be able to make that next leap of understanding the Medical Practice Act, our laws, etc.
Okay, great. Thank you. Any public comments from the audience?
Yes, go ahead.
And from those on the phones?
I just
Please.
wanted to clarify for the expert training that we do have all representatives from all sides, both health quality, the AG's office, we have a retired administrative law judge, we have a medical consultant that participates in the training. So the training that's put on really is coming from all the different aspects. And then they talk about the mock cases and actually get to vote during the training with little clickers as far as what standard of care issues are, and then the audience gets to see how everybody voted in, whether the group felt something was within or with not the standard of care.
And I appreciate that, and I guess the point is now you're doing that, and that's great to know that that was happening upstream, but how does that get translated down to the box of records that show up into the XYZ doctor's office for his or her review? And that communication, I think, is important.
And Dr. Bolat, I wrote down everything you said, and we will discuss among our management staff what, if anything, I can do when the rubber hits the road and it is filed. It's no longer some figment in anyone's imagination. It is filed, and it is going to trial. Because definitely experts really always think it's going to settle, and that is usually true. But then the person who doesn't want to go to trial is there. And I can do a lot on our end to make sure that they understand those concepts, because you're absolutely right. You hit it right on the head. It's not what you do in your practice, it's what the community that you're part of practices.
That's right.
And that is one of the major pitfalls. And it is adversarial. And I think our lawyers try very hard to play devil's advocate when we meet with our experts. And sometimes that has an unintended effect that they definitely don't want to go to hearing. But so it's a very delicate balance, but it starts with open communication with the expert and moving forward, because without them, none of our cases would go forward. They're a very critical part of the cases, as is the patients that bring forward the complaints, trusting that we will do something with what happened to them to protect the public at large.
Thank you.
I actually attended the expert witness training 2 years ago. It's actually very good, comprehensive. Any board member welcome to join. But of course, there's always room for improvement. And actually, one of my to-do lists is to go through the syllabus or training before March with our staff, with your input, and see how we can make it better and make it more worthwhile for individuals to attend to. So great, thank you. Any public comments from the audience, from the phones? No.
Do we have any comments on the phone?
No phone comment.
Great, thank you. Thank you.
Thank you.
So moving on, agenda item 8, Ms. Dell will provide a presentation on the probation unit's roles and functions. I spent a day, January 5th, on the in the Sacramento office with the probation unit. We met about for the whole day with ex-staff member, work on some cases, the real cases, look at the files, and also understand the whole process, also review most of those disciplinary guidelines. And all I can tell you is that all I can see is the passion and commitment of our staff member that they share with the board member to carry out our mission of the board is to public protection. They drive to many places to make unannounced visits, and they look at every line, they check with every hint they have to make sure the doctors on probation act properly. We also have the queen of body fluid testing. There I learned a lot about body fluid testing, the glitches and how we can improve on the system, the minute amount of alcohol level that your hand sanitizer can change the reading, etc. So, but I really think my day there was worthwhile, and any board member invited to join them, and it's my goal to be there at least once in between the board meeting to get updated, to be involved with them. So, Ms. Dell, please, your presentation.
Okay. Thank you, Dr. Yip. My presentation is full of a lot of information, so I'll do my best to get through it as quickly as possible. And to my right is our Associate Analyst, Virginia Gerard, who handles our biological fluid testing. So if you have any additional follow-up questions, she's here to also assist with that. So my presentation overview is going to highlight the organizational structure of the probation unit, identify the various positions with the unit, explain the roles of the positions, discuss the possible probation terms and conditions that can be imposed, discuss how probation staff monitors compliance with the terms and conditions, and then I'm going to wrap it up with some concepts and some areas where we have focused improvement efforts with the unit. The learning objectives I hope that you can take away from this presentation is bring awareness to how the unit monitors licensees on probation, create an understanding as to what actions are taken by the unit when licensees violate a term or condition of his or her probation, and to acquire an appreciation that to achieve optimal success of the program, it is a continual process, reviewing the way business is conducted constantly and making improvements over time. The probation unit was created in 2008, and to give you a little bit of a historical information on that, on January 1, 2006, the board's enforcement program entered into a new working relationship with the Health Quality Enforcement Section of the Office of the Attorney General, and thus the vertical prosecution model was created pursuant to Senate Bill 231. At the time of this new working relationship, the board's probation unit was staffed by sworn investigators. However, due to ongoing caseload, staffing shortages, and problems with recruiting and retaining sworn investigators, sorry to talk about. Enforcement Program Management decided to transition the sworn investigators to the Office of Investigative Services and then create a new classification of non-sworn personnel to monitor the probationers, to include the function of identifying those cases which will require further investigation. The development of this new classification was developed to take the existing non-sworn investigator assistants and transition them into the training and development assignment into the Inspector Series classification. The reorganization and transition took some time, and eventually the board's current probation unit was created in 2008 with the Inspector Classification Series performing the full monitoring activities of the unit. The transitioning of the sworn investigators to the Department of Consumer Affairs Health Quality Investigation Unit in July of 2014 did not change the structure, nor did it impact the daily operations of the probation unit. There are 3 offices within the probation unit. There's Probation North, Probation LA Central, and Probation South located in San Dimas. And within those 3 offices, there are a total of 25 non-sworn staff to include managers, supervisors, inspectors, analysts, and technicians. And just to provide some statistics, during fiscal year 14-15, the probation unit monitored 614 cases, which equates to a caseload of roughly 36 cases per inspector. 89 additional monitoring cases were inactive because the probationer is out of state as of June 30th, 2015. As you know, this number is fluid because as licensees are placed on probation, some licensees complete their probation. Here is an organizational structure of the probation unit. with 1 manager, 3 inspector supervisors, 15 inspectors, 2 analysts, and 3 management service technicians, and 1 office support handles the whole probation unit for a statewide program. Since 2008, this has been the board's organizational structure for the probation unit and has not changed. Briefly on some of the functions of the classifications, the manager plans, organizes, and directs the statewide operation of the unit. The Inspector 3 supervisors are now handling the PC-23 and interim suspension order restrictions that need to be monitored for a licensee. They prepare cases for citation, fine, and order of abatements. They transmit the cases and prepare the memorandums that go to the Attorney General's office for violation of probation. They conduct quarterly case reviews with each inspector, and they review the performance of the inspector to provide direction and monitoring of the cases. The Inspector 1s and 2s are the ones that actually monitor the cases and deal with the licensees, the probationers, on a daily basis. They schedule intake interviews. They meet with the probationers quarterly. They interview the practice monitors, the third-party chaperones, the billing monitors. They approve all educational and training courses. They schedule psychological, psychiatric, medical evaluations. They monitor the missed calls for biological fluid testing. They prepare detailed quarterly reports. They identify noncompliance issues and send letters of noncompliance reports to make recommendations for further disciplinary action. The management service technicians are assigned to monitor the pen cases, the in-state non-practice probationers, and the toll cases where probationers are in the state of California. And the office technician provides clerical support to the program. The associate analyst position, which Ms. Gerard is in that position, is the biological fluid testing analyst. She maintains a caseload of physicians who also are issued public letter of reprimands and monitors the training and restrictions that are entailed with the PLR. She monitors the biological fluid testing program to ensure compliance with the requirements to abstain from the use of drugs or alcohol. She ensures the biological fluid tests are random and observed and analyzes the results from the contracted laboratory. She prepares cases for transmittal to Attorney General's offices when it requires a petition for revocation of the petition for a biological fluid test, and she also processes petitions for early relief, termination, and modification of probation. Statutory authorities. The disciplinary guidelines were created to implement the mandates of the Business and Profession Code Section 2227 and 2229. And of the 5 actions that can be taken pursuant to Penal Code Section 2227, placing a licensee is one of those actions by placing him on probation. Business and Profession Code 2229, when exercising disciplinary authority, this code states public protection shall be given the highest authority and disciplinary action shall be calculated to aid in the rehabilitation of a licensee, restrict the licensee's scope of practice, and order restrictions to be placed upon the licensee's practice. In other words, probation unit is responsible for monitoring physicians who have been subject to disciplinary action by the board and as a result have been placed on probation with ordered terms and conditions that must be met. The ordered terms and conditions are designed to remediate and rehabilitate the physician as well as ensure the public is protected. Moving on to some conditions found in the Manual Model of Disciplinary Orders and Guidelines. It's important to stress that these guidelines are optional conditions and that deviation is appropriate when the case warrants deviation. There are 23 optional conditions, and the use of the optional conditions within the orders and stipulated agreements depends on the nature and circumstances of the particular case. Deviation from these conditions is appropriate when the case warrants deviation. I'll now explain most of the optional conditions. And first, there was an error in your packet. Condition number 4 is an actual suspension, and the controlled substance conditions are numbers 5 through 9. An actual suspension is when a licensee is suspended from practicing medicine. To monitor this condition, staff visits the probationer's place of employment and or calls the place of employment and attempts to schedule an appointment with the physician. If there is reason to suspect the probationer is practicing medicine, the probation unit may make a referral to the Health Quality Investigation Unit to conduct further investigation to determine if the probationer is practicing. If determined the probationer is practicing, a case is transmitted to Attorney General's office for violation of probation. Depending on the circumstances of the case that place the physician on probation, an immediate suspension order may be pursued if found to be practicing with a suspended license. Controlled substances conditions 5 through 9. Condition 5 and 6, total restriction and surrender of DA permit, they go hand in hand. These conditions prohibit the probationer from ordering, prescribing, dispensing, administering, furnishing, or possessing any controlled substance. Inspectors run cures reports every quarter to see if the probationer is prescribing controlled substances. Inspectors verify with the Federal Drug Enforcement Agency whether the probationer surrendered his or her DA permit, and the inspectors communicate to the DA that the physician is on probation and cannot be issued a new permit without prior written consent by the board. Condition 7, controlled substance partial restriction. This condition limits the types of controlled substances, controlled drugs the probationer can order, prescribe, dispense, administer, furnish, or possess. For example, a probationer may be ordered to only prescribe, dispense, and furnish Schedule 2 and 3 types of controlled drugs. Inspectors again check cures to ensure compliance with this restriction and also contact the DEA and advise them of the restriction. The inspector will submit a request to the DA for the DA to issue a new permit that limits the types of controlled drugs the probationer is permitted to order, prescribe, dispense, etc. Condition 8, controlled substance maintain record logs. This condition requires the probationer to record all controlled substances ordered, prescribed, dispensed, etc. Inspectors review the probationer's recorded logs every quarter at a minimum and compare the logs to a cures report, looking for discrepancies in compliance with this condition. Condition 9, controlled substance abstained from use. This condition requires the probationer to refrain from the personal use or possession of controlled substances. At the intake interview, the probationer is asked to provide a list of medications they are taking and are instructed to notify the inspector within 15 days of receiving any lawfully prescribed medication. The board's biological fluid analyst is provided a copy of this list of medications. If the probationer has a confirmed biological fluid test for any substance, whether or not lawfully prescribed, and has not reported the use to the board, staff immediately contacts the probationer for an explanation as to why he or she tested positive. This is done to rule out any mitigating circumstances before issuing a cease practice order. For example, a probationer could injure him or herself and be legally prescribed a controlled substance and then subsequently be asked to take a biological fluid test. The probationer would not be in violation if he or she still has time to report the drug within the 15-day time frame. So the circumstances must be investigated, and if the evidence warrants a violation of the condition, the board will issue an immediate cease practice order. Biological fluid test conditions 10 and 11. Condition 10, abstain from alcohol use. This condition requires the probationer to refrain from the use of products or beverages that contain alcohol. If the probationer has a confirmed biological fluid test for alcohol, staff swiftly gathers evidence from the testing lab and the lab's medical reviewing officer to support the positive test for alcohol. Once sufficient evidence is gathered, staff immediately requests the issuance of a cease practice order. Condition 11, biological fluid testing. This condition requires the probationer to contract with a board-approved laboratory and requires the probationer to check in daily with the lab to see if he or she must immediately submit to a biological fluid test. Similar to Condition 10, if the probationer has a confirmed biological fluid test for controlled substances or alcohol, staff swiftly gathers the evidence from the lab and the medical reviewing officer to support the positive test. Again, when the evidence is gathered, staff immediately requests the issuance of a cease practice order. At the October board meeting, a public comment was made that at the board's sunset report, 306 drug tests came up dirty by probationers in the 2011-2012 fiscal year, but that probation unit only reported 33 probation violations to the Attorney General's office and 34 petitions to revoke probation were filed. The commenter alluded that the numbers do not compute and stated if the probation unit's process to detect violations of probation is not working, then patients are at risk. Board staff was very concerned with this comment and researched the accuracy of the statement. It is important to communicate that a footnote is referenced in the Sunset report regarding the 306 reported positive drug tests. The footnote states the number of positive tests include those where the licensee had a prescription for the substance. For example, many probationers take Suboxone as part of their treatment to bout opiate dependence, and this drug will show as a positive test result. And many probationers are ordered to abstain from controlled substances, but not alcohol. And in these instances, the test will show positive for alcohol, but would not constitute a violation of one's probation. Condition 13 through 18 require the probationer to take courses or participate in programs related to education, prescribing practices, medical record keeping, professionalism, professional boundaries, or clinical training. These conditions require the probationer to complete the courses or programs within specified timeframes. To confirm compliance with these conditions, inspectors receive completion certificates from the probationer, and inspectors may also verify with the program that the probationer completed the courses or programs to ensure compliance. Condition 20, psychiatric evaluation. A board-appointed certified psychiatrist conducts the psychiatric evaluation. Inspectors pick the psychiatrist from the pool of experts the board has within its expert reviewer program. They review the CV, they check ABMS for medical specialty, and they check prior discipline and recent complaint history before selecting the psychiatrist. Condition 23, monitoring. This condition requires the probationer to nominate to the board for approval the name of a licensed physician and surgeon that will monitor the probationer's practice or billing methods to ensure the probationer's practices are within the standard of care, or whether the probationer is practicing medicine safely, billing appropriately, or both. The practice monitor conducts monthly chart reviews and submits written quarterly reports. Any concerns are reported immediately to the board and reported to HQIU to conduct further investigation. The monitor once a year conducts a site visit review of the probationer's office practices in addition to reviewing patient charts. The monitor follows a board monitoring plan that outlines the percentage of patient charts that are to be reviewed by the monitor. Inspectors review the practice monitor's written quarterly reports for compliance with this condition. If the probationer fails to obtain or replace a practice monitor within the specified time frame, the inspector is immediately requests the issuance of a cease practice order. Condition 25, third-party chaperone. This condition requires the probationer to have a third-party chaperone physically present during all consultations, examinations, or during treatment of specified patients, and requires the probationer to maintain a log of all patients seen for whom a chaperone is required. The chaperone must be approved by the board and is required to sign and date each patient's medical record at the time the chaperone services are provided. Inspectors review the chaperone logs and call patients to verify that a chaperone was present during the consult, examination, or treatment. If the probationer fails to obtain or replace a chaperone within the specified time frame, the inspector will immediately request the issuance of a cease practice order. Prohibited practice, condition 26. This condition forbids the probationer from practicing, performing, or treating a specific medical procedure, surgery, or specific patient population, and requires the probationer to notify patients of the prohibited practice. In addition, the probationer is required to maintain a log of all patients that receive this oral notification. Inspectors review the logs for compliance and rely on practice monitors if ordered or stipulated in the order to confirm compliance with this condition. The practice monitor, when reviewing patient charts, will look to see if the probationer has violated the prohibited practice condition. When violations of these conditions occur, the probation unit sends a transmittal with supporting evidence to establish the alleged violation to the Attorney General's office for a petition to revoke probation. Moving on to the new uniform standards for substance abusing licensees. These standards contain new conditions that must be applied to cases involving substance abusing licensees. For clinical diagnostic evaluation reports, these are conducted by a board-appointed, board-certified physician and surgeon. The evaluator's report shall state whether the petitioner has a substance abuse problem, is a threat to him or herself. They need to recommend treatment or recommendation for rehabilitation to practice medicine safely. Any concerns during evaluation shall be notified to the board within 24 hours of this determination. The probationer shall not return to practice until he or she has at least 30 days of negative biological fluid test or biological fluid test indicating a prohibited substance. Respondent cannot practice until notified by the board or designee he or she is fit to practice medicine. Violation of this condition is a major violation. Notice of employer or supervisor information. Probationer shall provide the board with information regarding all employers and supervisors and shall provide written consent for the board, worksite monitor, and employer supervisor to communicate together regarding the probationer's work status, performance, and monitoring. Failure to provide this required information is considered a minor violation. Biological fluid testing. Immediately, probationers shall submit to testing and daily check-ins to determine if testing is required. Unlike the other guidelines, the probationer shall be subjected to more random testing up to 104 tests during the first year of probation. During second year of probation, remaining throughout the terms of the probation, they shall be subject to submit to test up to 104 times per year. Only when no positive tests in the previous 5 years of probation may testing be reduced to once a month. When a cease practice order is issued for violations of this condition, the respondent must leave the place of work, and the board will be required to notify employers, supervisors, and worksite monitors that probationers cannot practice medicine while the cease practice is in effect. If confirmed, the positive test is evidence of the use of a prohibited substance, probationer has committed a major violation and is subject to consequences set forth for violating a major violation. Again, this monitoring of the substance abusing licensee terms and conditions are performed by the biological fluid analyst. Substance abuse support group meetings. Probationers shall attend support group meetings and at least once per week or as ordered by the board. Probationer is required to provide the board with contact information regarding the group meetings, and inspectors will be contacting the group facility to confirm probationers have attended the required meeting, and the facility is also required to provide the board with any unexcused absences within 24 hours. A violation of this condition is considered a minor violation, however, can be deemed a major violation if multiple unexcused absences occur. Worksite monitor. Approved by the board and cannot be an employee or supervisee of the probationer. Worksite monitor must at least meet with probationer face-to-face at least once a week, must report concerns to the board within 1 day of occurrence through a verbal notification, and written report must be provided in 48 hours. Inspectors will ensure all elements are in this report and will have regular communication with the monitor about the probationer. Failure to secure the monitor is considered a minor violation. The standards for substance abusing licensees, unlike the manual model of disciplinary guidelines, define what would be considered a major or minor violation of probation. Major violations are failed to undergo clinical diagnostic evaluation, commit multiple minor violations, is found to treat patients while under the influence of a prohibited substance, or engages in danger or alcohol-related act that is a violation of state or federal law, fails to undergo biological fluid tests when ordered, and knowingly defrauds or attempts to defraud a biological fluid test, or fails to comply with any term or condition of his or her probation that impairs public safety. Major violations that can result in a cease practice order. We can increase the frequency of biological fluid testing or refer to the Attorney General's office for further action. Minor violations are fails to submit required documentation in timely manner, has an unexcused absence at a required meeting, fails to contact a worksite monitor as required, fails to comply with any terms or condition of his or her probation that does not impair public safety. Should this occur, a cease practice order could be issued, practice limitations can be placed, supervision can be increased, documentation can be increased, a cite and fine or warning letter can be issued, the probationer can undergo clinical diagnostic evaluation, or the board can take other action as determined. Since my short time with the board as the Chief of Enforcement, I have been reviewing the way business in the probation unit is conducted to include conducting case reviews and review the unit's policies and procedures manual. Some improvements identified within a 6-month period are: we are going to hire a new senior staff position, a staff service manager 2, which will be able to assist the daily operations of the probation unit. They will provide oversight in more case reviews and will be able to develop training for the probationers. They will implement a random quality assurance case reviews that will happen in addition to the quarterly case reviews by the Inspector 3s. We've also restructured the duties performed by analysts to provide oversight of licensees subject to biological fluid testing. We will now have 2 analysts that will be overseeing the biological fluid testing, so Ginger will get some relief with her caseload. Inspector 3s are now responsible for monitoring the PC-23 and the ISO restrictions and conditions imposed. We are reviewing all form letters, templates, and checklists to ensure they are up to date with current policies and procedures. We are improving the way that transmittal packets are written to include the gathering of evidence to support a violation of probation. We have added language to the board's public letter of reprimand to include timeframes for completion of courses and added language that noncompliance may result in further disciplinary action for unprofessional conduct. And also, we are examining the biological ETS threshold that alerts or demonstrates that someone has significant consumption of alcohol. This concludes my presentation, and I'd like to finish by stating, since the last board meeting in October, the probation unit has submitted in less than 3 months 10 transmittals to the Attorney General's office petitioning to revoke a licensee's probation for noncompliance with ordered terms and conditions. I hope with the enhancements mentioned, the development of new procedures, and the enforcement program's continual assessment of the unit's practices will bring confidence to the board members and the public that the probation unit is effectively monitoring licensees placed on probation. Thank you.
Comment, please.
I do. I was trying to figure out how to get the phone to stop beeping, but I can't figure it out, so I apologize. It sounds to me like you've really hit the ground running, and I want to thank you for all of that information. But what would you say would be an optimal time lapse between a break in the monitoring responses to some sort of next steps? What would be 24 hours, 48 hours, a week, a month?
A break meaning for what violation?
For 1 through 26 in the beginning, for the...
Well...
Or for any, you know, I mean, we're talking about serious breaches of competency.
Right. Well, I know, like, the programs, they do have specific timelines. They have the probationer is to enroll within 30 days.
No, I'm
and
talking
complete.
about, let's start with the more egregious kinds of situations, alcohol, substance abuse, infractions.
Those are immediate, so
What does
upon
the term immediate
notification,
mean to me, the consumer?
within 24 to 48 hours, the cease practice is submitted up to executive office for approval, and the packet is submitted to the Attorney General's office to move on a petition to revoke probation.
And what kind of time frame does that take?
24,
48 from you, and then?
To the Attorney General's office?
To the completion, till it's complete.
I'm not quite
How
sure.
long should
Maybe
it take?
Kim has.
So it really depends upon the violation that is brought forward. Just as you said, Ms. Yaroslavsky, if it's a drug or alcohol, and I believe Ms. Delp touched on this too, as soon as we get that positive back, the first thing that happens is Ms. Gerard here gets a call to the individual to find out what the reason was. Then once that happens, depending on the language, whether it's the old language or the new language for the violation, then we start the packet to issue a cease practice that goes out to the physician. Like Ms. Delp said, our plan is between 24 and 48 hours. Once that goes over to the Attorney General's office, if they have the old language, they are put on the spot right then and there because they only have 15 days to actually file an accusation. Once that accusation is filed, it's supposed to be heard by an ALJ within 30 days, but what usually happens is both sides will waive that 30-day time limit because they need to prepare for their case. So then it depends on when that case is going to get set for hearing. That's all out of our control, so it could be anywhere from 6 months to a year, depending on how long it takes to get that set for hearing and when the hearing is held. But according to what it states in the disciplinary guidelines, that should be set within 30 days. I don't know. I'm going to look at Gloria to see if we've ever actually had one that has actually gone within 30 days. It's probably very rare. But at the same time, the individual isn't practicing, so he's trying to
So
get
there's
it.
no practice, so
There's
I want to be clear on
not
this.
not after a cease practice, and there are certain conditions that have that cease practice language in there. So let's go with one that's maybe not as egregious. So let's say he doesn't have a give me one, Ginger.
No, I want to be real clear that I heard you correctly, that once a cease practice has been issued within 24 to 48 hours, that person is no longer practicing.
Right. They have 3
End of
days
conversation.
from the time that is
Right.
issued to them. They can't practice, and then they don't practice until the resolution of that accusation, or it'll be a petition to revoke. They can't practice until that's over. However, if we miss any of those deadlines, then that automatically lifts that. That's why it's so important for the AG's office to get the accusation or the petition to revoke filed and all of that to occur. Now, one thing is if it's a minor violation, let's say they don't send in their quarterly report, we'll send a letter back to them. And usually the monitor will know, have a deadline. That might take a couple weeks for them to hit everybody on their roster to see, okay, did this person send in their quarterly report? If they didn't, then they'll send a letter to the individual or contact them by phone and ask why they haven't complied with their quarterly report. So it really depends on what the violation is.
Right, I can understand that. So, but could the public assume that within a certain period of time, regardless of what the violation is, immediate to something out there 3 months, out there 6 months, out there a year, and should that time out there be pulled back? I'm just suggesting that when it comes to, when push comes to shove, I understand that there are things that happen or get in the way of, but by the same token, that's not the norm. That's the outside the norm. So for normal process, should the public expect that from 24 hours to what date, what time would be appropriate? I mean, I'm not saying you need to answer us now, but I sure would like to have an answer.
Yeah, and we can look at that and come back with some issues, some answers to that question. The one thing is it's the same that we would see with when we get a complaint. We want to move those as fast as possible. Now, granted, we have an individual who's already been found to have violated the Medical Practice Act, and so we want to act on those as quickly as we
Correct.
can.
So that's number one. Number two, the thing is that when a probationer signs a stipulation agreement as to what will be the terms and conditions of that probation, I know I've asked the question before, and I've probably received a very smart, reasonable answer, and I forgot, but at that point in time, could there be some legal ramifications that they are signing that they understand within the opportunity of having to be issued a stop practice, that if they break the terms and conditions of probation, they assume that this might happen to them? I mean, is there something that we can put of some kind of stronger language so that the person signing, the person that has been the applicant that is found to be in probation, has broken rules and regulations, has signed specifically that they understand that they might be asked to be stop practice? Would that give you?
I know that Virginia, I know at the intake interview, they do sign many documents.
Right, I know, I've read them.
And that's what I was going to say. There's two places where that comes in. First of all, that should be happening with his or her attorney when they're getting ready to sign that. That attorney should be going over all of those terms and conditions and explaining that to them, as well as our deputy explains that to the other respondents' counsel, what these mean. Then when they do that intake interview, they sit down with that order. Our probation monitor literally sits down and walks line by line through each of those terms and conditions that are on that decision and makes sure that that individual knows if you don't comply with this, it says right here, we're going to issue you a cease practice order. So that's going to happen.
And the person is signed that they understand that.
Do they
Yes,
sign anything?
they do sign
So
it.
they do sign.
Acknowledgement of decision.
Okay.
Okay, I want to just take it out of the realm of possibility and put it into the realm of reality.
It's interesting, our probation monitors have reported back that where the breakdown seems to be, though, a lot of time is in that upfront with their own attorney, that all of a sudden when they sit down with our probation monitors, they're like, I didn't realize it was going to do this when I signed the stipulation, which is too late for that individual because it is now that this matter is effective. But at the same time, we do explain it to them and they do understand it at that point.
One last question. You mentioned you're going to have a new hire.
Yes.
Can I ask you when that's going to take place?
We are conducting interviews on Monday.
And you have candidates?
Yes.
And you're prepared to hire someone from those candidates?
That is my plan, yes.
So we would have a new employee within what framework of time? I know I'm pulling, but I just, I'm hiring, I'm going to hire, we need more employees, I want to...
Well, I can commit to making selecting a candidate within 3 to 5 days, and then I pass it off to the Department of Consumer Affairs, who needs to do the final approval. We can continue.
So can I say by
for
March 1st we'll have a new employee in place? Can I say by October 1st we're going to have a new employee? What's the story here? Come on.
would be March 1st, no later than March 31st.
Okay, thank you.
And again, that is because that individual has to stay at his or her job, depending on if it's a promotion or not, for either 2 weeks or 30 days. So it
I'm
depends
just
on.
trying to understand the process that we're going to have a new employee within a reasonable amount of time out of our office in the hands of DCA that are going to return that information and make it happen.
And both our staff and DCA staff have been really timely on our hires, so.
I noticed, so I
we
just
should
want to,
have
I
it.
thank them for that, and I thank you for that, but I'm sitting on this side of the table, I want to make sure of that.
Yep.
Thank you.
Yes, I have just a technical question. You were talking about that footnote and saying whether or not the urine test was positive or negative. Who is responsible for running those tests, and how do we determine we use a positive or negative versus a test that'll say, I took NyQuil last night, or I took my Suboxone, or I took my oxycodone?
I'm going to defer to Ginger, who's been doing the biological testing.
Thank you.
Hi, Doctor.
Good afternoon.
I just want to say it's a real pleasure to sit across from my own board, and I am slightly nervous.
We don't know what you're going to say, so there's no wrong answers, don't worry.
Ma'am, I heard about the teeth. I was here for that.
My dentist is very appreciative of my teeth.
Yes, ma'am. The biological fluid questions, yes, I was upset at the large number that was reported, and actually we gave those numbers to the board, and we put that footnote down there. But your question regarding NyQuil, NyQuil would test positive for alcohol. That would be one violation if a person is not supposed to take alcohol, but dextromethorphan is not usually an issue depending on the substance of abuse for the physician. Did you have another?
Right. Basically, the question is, go ahead.
I can follow up. So what happens is we actually contract with First Lab, and so they do all of our testing. Once that positive comes back, so they have a panel that they run it against, and they look at that. I think ETG is set at 250 milligrams. Is that?
It's at 250, the threshold.
50 is the threshold. So when that comes back as a positive, we're looking at that medical reviewing officer to enlighten us as to could that be an incidental exposure, or is this actually a true positive? And then that's when we start down the process of calling the physician and then going ahead and violating him.
And that is one of the enhancements that we're going to continue to look at, is the threshold that we're talking about for the incidental exposure. We're going to be meeting with some experts to get a firmer understanding what the threshold is, and are looking at moving into procedures that when it hits a certain threshold that we can go in and set a biological fluid testing and request it ourselves at the board level, not rely on the lab, and set it and request a blood test.
I see. So you would set it so you might have a reflex test. But another specific question is that there are, right, we could run a lab that would say this is Suboxone, this is
Yes.
oxycodone.
Yes.
Yes.
It
So
says specifically.
so you do that
Yes,
type of
there's
testing.
panels.
Oh, that's what I thought. So I was unclear about how some of it was not picked up, because I would want to know whether, because if the if the person's on Suboxone, that means they're under treatment.
Yes.
Right? So that makes a big distinction.
And we can tell what the drug is that they've tested positive for.
And actually, naltrexone is probably responsible for about 150 of those positives,
I
because
see.
we have about,
And they're under treatment.
right, so, yes, doctor.
Thank you.
Any other comments? But some of you think the presentation is long and tedious, but that reflects the kind of job they have to do every day. A lot of work. So thank you. So, any comment from the public? Ms. Feldman?
Good afternoon, Dr. Yip and members of the Enforcement Committee. Julie D'Angelo Felmuth from the Center for Public Interest Law, and I'm the former Medical Board Enforcement Monitor. I really appreciate this very detailed review of the probation program, which I consider to be one of the most important functions of this entire board. Here you have a physician who has been afforded full procedural due process and for the most part has agreed to terms and conditions of probation. And that's strike one and strike two in my book. And if they don't follow those terms and conditions of probation for whatever reason, we need to be assured, in the interest of patient safety, that your probation unit is picking up these violations. As you may recall, I was the public commenter who noted that during 2011-12, there were 306 dirty tests, yet only about 30-ish petitions to revoke probation were recommended by the board and filed by the AG's office. And the response apparently is that that includes dirty tests that are actual dirties and also positive tests because the physician is taking some lawfully prescribed medication. I would suggest two things. First, it is a probation violation for a doctor not to report to the probation inspector that he or she has been prescribed a medication which might trigger a dirty test. That's a probation violation. And so when you go through the terms and conditions of probation for these folks, that's something you need to focus on with them. Also, including that information in one big lump, even with that footnote, is not really helpful. I would suggest to you that if there's a way to do this, separate out actual dirty tests from positive tests due to lawfully prescribed medication. The final thing I'd like to say is that this function is so important. I'm concerned about the caseload. I'm concerned about hearing that there's approximately 36 cases per inspector. I'm concerned about the fact that that's almost double the caseload for HQIU investigators. And I think maybe you should take another look at this unit, the staffing of the unit, to determine whether you need additional probation inspectors due to the crucial importance of this function. Thank you very much.
Thank you. We share your comment. Any comments from those on the phone?
If I could just add that, I mean, those comments are valid, and I think just wanted to point out we're taking those steps by hiring a manager and another biological fluid analyst, and we are looking at the workload, and we are assessing it through our reviews, and it probably would eventually turn into getting more inspectors after our review.
So I apologize, but within that check, and I appreciate Ms. Felmuth's remarks as well, if there's a way of taking a look at outcomes, so if you take a look at today with X number of employees, what the time frame line is, and what you're trying to reduce, is it by 5%, 10%, 3 weeks, a month, a year, if we'd have something more that we could wrap our arms around and understand, it might not be one employee, you might need to hire 3 employees. You know what I'm saying? That there's got to be a validation of what you're doing based on information. So at some point, come back to us maybe. Thank you,
And
Dr.
that would
Yip.
just so you know, that same concept would also be applied in the complaint unit, not just in probation.
Absolutely.
So, I mean, that's just
I know that
our
staff is
vision.
always doing that, but
I'm just saying that's management's vision, is that we are going to be providing those statistics and looking at all the programs, not just within probation.
I know, but we're talking about this now. That's why. But thank you.
Yeah, we definitely need more help, but I think the fortunate thing is that really our staff is so committed, and even 35, 40 caseload, they really do a good job. Really. So, any comments from those on the phones?
Do we have any comments on the phone?
No comments from the phones.
Okay, great. So we move to almost the last item, future agenda. Any comments from the board?
I would like to hear information as to outreach opportunities within the medical expert reviewer after your conference, but as well as what we're doing as far as reaching out and how the response has been and what the methodology is. I'm not sure if it's for this one or the other, but I think it's important for us to have a finger on the pulse of that, and if we need some help, we need to participate. And I would be happy to volunteer.
Yeah. We're actually doing the outreach before the meeting, so.
Yes, I know. So proactive, reactive, whatever,
Absolutely, great. Any comments from the audience? Any from the phones?
Do we have any comments on the phone?
No comments.
Okay, well, we'll move to the last item. We need someone to make a motion to join the meeting.
So moved.
Second.
Great, thank you. Thanks, Ms. Delp.
Can we take
Good job.
5 minutes before the next meeting starts, sir?
I mean, it's up to the next
Pardon?
chairman, so not me.
5 minutes ago? 20 minutes ago? So I'm trying to do stuff because I'm seeing you see who's in the audience.
Okay, now we can officially begin. Good afternoon. Welcome to the Public Outreach, Education, and Wellness Committee meeting. I'm Dr. Ron Lewis, the chair of the committee, and I have some basic comments to read prior to my beginning my presentation. They're usually the script, the official script, so I'm going to read them. Bear with me. I want to ask all of you to please turn off their cell phones to silent and off the table for the committee members. You may notice board committee members assessing their laptops during the meeting. They're using their laptops solely to access board meeting materials that are in electronic format. This is an official business meeting of the Medical Board of California, and as such, disruptions of the board's business will not be tolerated. We have a designated time on the agenda for public comments and ask for public comments on each agenda item. I ask that you be respectful of the need for us in the board to conduct business, and should anyone disrupt this meeting, I will ask the person to conduct himself or herself in such a manner that permits the board to transact its business. This meeting will be available via teleconference. Individuals listening to the meeting will have an opportunity to provide public comment and will be assisted by a moderator who will be facilitating the teleconference process. For those members of the public participating via teleconference, please wait until the moderator has introduced you before making your comments. To request to make a comment during the public comment period, press the star key on your phone, and you will hear a tone indicating that you're in the queue for a comment. And if you change your mind, do not want to make a comment anymore, just press the pound sign and you'll be removed from the queue. Assistance is always available throughout the teleconference meeting, and to request a specialist, press *0. Now, each person is limited to 3 minutes per agenda item. However, during the agenda item number 2, which is called public comments on items not on the agenda, the board has limited total public comment period for individuals to 20 minutes. In addition, public comment for individuals here at this meeting will also be limited to 20 minutes. Therefore, after the 20-minute period, no further comments will be accepted. During public comment on any other agenda item, 10 minutes will be allowed for comments from individuals on the teleconference line and those here in the audience. After 10 minutes, no further comments will be accepted. The business services staff here will be assisting me with receiving public comments via teleconference and during this meeting. The board welcomes public comment on any agenda item, and it's board's intent to ask for public comment prior to the board's taking action on any agenda item. If for some reason I forget to call on you or ask for public comment, and you wish to speak on a particular item, just raise your hand and I'll recognize you. I would like to request all speakers to complete a presenter slip so I can call on you by name at the appropriate time, and that the record of this meeting can be full and complete. However, this is completely voluntary. Please give the speaker slip to Ms. Mose, who is right there in the middle. And I'll do my best to call upon everybody who has submitted a slip or has questions from the audience. I want to remind all speakers, please stay on topic for the agenda item and keep your comments limited to 3 minutes or less. Okay, first order of business is that we'll call the roll call. Ms. Mose, could you call the roll?
Dr. Hawkins?
Here.
Dr. Kraus?
Present.
Dr. Levine? Present. Ms. Pines? Here. Mr. Serrano-Soul? Present. Ms. Yaroslavsky?
Present.
And Dr. Lewis?
Present. Thank you. Thank you very much. We have quorum. Okay. The next item of business, number 2, is public comments on items that are not on the agenda. Now let me think. I'm just looking through my list. Bear with me. Does anybody in the audience have public comments that are not on the agenda? Raise your hand. No? Anybody on the telephone?
Do we have any comments on the line?
No comments coming
No
from the
comments
phone.
on the
Attendees.
telephone. Okay. So I'm seeing none. I'll move on to the next agenda item, which is public comment. Approval of the minutes for the October 29th, 2015 Public Outreach, Education, and Wellness Committee meeting.
So moved. Second.
We have a motion to move. We have a second. Any comments from members of the committee? Seeing none. Any comments from members in the audience here? And any comments from members or on the telephone?
Do we have any comments on the line?
No comments.
We will now take a roll call vote.
Dr. Hawkins?
Yes.
Dr. Kraus?
Yes.
Dr. Levine?
Yes.
Ms. Pines?
Yes.
Mr. Serrano-Soul?
Yes.
Ms. Yaroslavsky?
Yes.
Dr. Lewis?
Yes.
Thank you.
Motion passes. Okay, now I'm moving on to agenda item 4, which means I'm on. So, but I don't want to do it sitting down. I'm going to stand over there. So bear with me. I just had to get up and move my hands, so, I can't do it sitting down. Is this going to work?
Beanie hand puppets.
This thing?
I have some at home, finger puppets. You want me to bring them next time?
Oh.
Okay.
No, here. No, put it here. Can you put it there?
We could do sign language.
Here. Testing. Live. Okay. Now, I'm not going to read word for word because I think you all can read it in the agenda and also on the screen here, but I'm going to sort of give you some introduction. You know, last meeting in October, the board heard a presentation from staff on the outreach to patient plan regarding informing patients how to verify physicians' licenses, physicians' disciplinary history, etc. And after that meeting, the board members, some of them made comments on how to maybe improve or alter the plan to make it more patient-friendly. And we also heard a lot of very good comments from the audience in similar vein. So what I did is I met with staff several months ago, and we sat down to look at the plan and also to rebrand it to make it really stand out, to reach as many patients and consumers as possible, and make it very easy and just send the message out there. This is what we want you, how we want you to be informed, and here are the tools on how to do it. So in that, oh, now it works that way, huh? Okay, so with that, we have a goal. And the goal says we want to reach as many patients in California as possible to make them aware of the Medical Board of California and their ability to verify physician's license on the board website. This will allow patients to ensure a physician is licensed, but not only licensed, also is in good standing with the board, meaning what's going on with their license, in other words. So let's look at a situational analysis. What do we think when you hear the word Medical Board of California? A lot of people out there really don't know what we do. So we thought, we got to get that message out. What does the board do? What does the board do for you as a consumer and as a patient? So knowing that, we have to get that message out there. We want to be able to give patients, consumers, the tools on how to obtain information using our website on their physicians, or potential physicians, because not everybody has one, okay? So we look at the target audience, and of course we would like every patient, we'd like every patient in California to be our target audience, right? But we thought, let's go and see where the low-hanging fruit is. Let's see who utilizes our medical services more frequently. And we thought, okay, we have senior groups that utilize it more frequently. We have various ethnic groups and communities that we need to reach out to. We have parents who have children. And we also have a very good group of legislators, be that state or federal legislators in California, that we could also use to assist us in this program. And we want to use this in a prioritized approach. What we didn't want to do is just throw darts out there, reach everybody, and put all these resources out there at one time. We thought, let's see where the low-hanging fruit is, who we can reach the biggest group and the biggest bang for your buck. So the low-hanging fruit. Now, what's our challenge? Challenge is money. We don't really have a budget to do this. We have to rely on Department of Consumer Affairs to provide funds to do this. So a lot of this we're going to be doing sort of from staff members who happen to be in certain locations that can do outreach, and also we're going to call upon my fellow colleagues on the board to also help with this outreach program. So we have two strategies to implement. We have current and ongoing event participation outreach, which Cassandra and her group have been doing now in various shopping malls and various events with groups of seniors and in neighborhoods. But we also need to partner with numerous organizations and piggyback on them to help with our campaign and focus, hopefully, on a particular month that's called Check Up on Your Doctor's License Month. So doctor checks up on you, you check up on your doctor. Can we... Now, in order to begin this plan, we've got to really do two things. We've got to develop a public service announcement that can be provided to various groups on the airwaves. So we're going to work on that to obtain a public service announcement. But also as important, or probably more important, is to develop a tutorial for the website on how you can look up a physician's license, see if they have a license and it's in good standing, meaning what is attached to their license. And later on, after my presentation, we're going to go through that with you. So hold your question on that, but you'll see that we've made enhancements to the website to really try to get that information and make it easy. So what we did in our meeting, I met with staff, and I want to thank Jennifer, Cassandra, and Kim for providing a lot of this input when we met. Let's prioritize, again, as I said, the low-hanging fruit. So who out there has the most population under their wing? We have utility companies. Almost everybody has a gas and electric bill, a water bill, or something. And you get those little announcements in the flyer, or you get on the bottom of your bill something about you're efficient, you're not efficient, your water, whatever. We thought, well, maybe we can contact these companies and see if we could piggyback on their mailing. Also, large amount of consumers work for the city, county, and state. And those of you, like myself, who work for the state government on your pay stub, you get your IRS, information. Maybe we can put an announcement, here's how you check up on your doctor. So we're going to hit these large groups of people as a prioritized approach. Then we have groups of seniors, although at AARP I think it's like 50 and over, so I don't want to call myself a senior, but we can look for groups like AARP. We can reach out to the various unions who have large populations of members, so they can provide their members information. many of them have conventions, they have meetings that we could either go to or provide some kind of announcement for them to hand out. And then we have things like iHeartRadio and other PSAs that we could distribute to outside entities. So this is in priority 1. So I think if we can reach that group, we'll get a large percentage of consumers and patients out there. But then we also go to priority 2. Now if you look at priority 2, these are things that are nice to have, but maybe we should just wait a little bit until we have done priority 1, and then let's look and see if we can then attack priority 2. So various other regulatory boards may be able to assist us with their membership. Community newspapers, school publications, PTA publications, invite media to events when we do our Focus Check Up on Your Doctor month, and provide them with information on this campaign. And here's a list of other outreach items that we could also do. And I want to emphasize, this is not one-time thing. We just go out there one day and reach all these people. This is an ongoing effort. This is like every day. So I don't want anybody to think that after this is done, we stop, we pull back, and we go on to something else. This is every day we're going to think about how to reach more and more people. Now, it's not going to be perfect. We're not going to reach every 100% of people out there. But I think if we reach a majority of people, give them the tools to be informed, that's the key word, informed patients, I think we will have accomplished a great deal when this campaign is up and running. Oh, I missed these two. This one? Yes. We have a lot. We and the board members, we have legislative days, and we're going to have one maybe February or March, or maybe 2 of them. We're going to meet with various members of the legislature, both Assembly and Senate, to talk about our program and roll out a Check Up on Your Doctor month. So we're going to ask them to reach out to their constituents, because they all have newsletters, and assist us in our campaign. And then I talked about the legislative day. Okay? It's hard to see it back here, huh? Okay, so that's basically the outreach plan in a nutshell. And you can refer to this list for more details, but I don't want to bore you with reading every single detail. But you get the idea. Be an informed patient, informed consumer. Okay, so we move on, right? To the brochure. We don't have. You want to just go? Let's go ahead, and if you don't mind, let's just go ahead and look at the brochure, and we'll take public comment on both of those items. Does everybody receive one of these? They're on the back, or my colleagues on the board? You all got that? Okay. So let's look at the brochure that was developed by the medical board staff. And I'm just going to hold it up like this and see if it sort of stands out. That's what we want people to grab it, stand out, grab it, and say, oh, what is this about? This looks medical. So here it is. Now, if you see the outside, it says, check up on your doctor's license. So check, stethoscope, medical. Be an informed patient. So then you open up the brochure, and it goes into more detail. Medical Board of California wants you to make an informed decision about your doctor, and then it walks you through how to access the website and a tutorial on how to look up your doctor's license or potential doctor's license, and then also see if there's any disciplinary actions attached to that license.
Can I just add on one thing on the brochure? We do have still the Verify a License on there. We're going to be changing that, but that's going to be talked about under Agenda Item 6. But I did want to let you know that this was with our old website. So some of this will be changed just because of our processes that we're going to be doing with our website. So some of this information on here will be changed, as well as the picture down here will have a different picture of the new website once we get it done.
Right.
So.
Now, I just want to call your attention to a couple things on this brochure, about in the middle and also on the back, because these are some of the comments from the last board meeting, is that our website had disappeared, almost non-readable, unless you had a magnifying glass, and we have our 800 number, because not everybody has access to a computer. Now, they have access to public libraries, maybe city and county government can be involved, somebody has a daughter, a nephew, or some 12-year-old that has computers, but for those who don't have access to a computer, they can call the phone number and get the same information. So we wanted to stress that, and we wanted to put that somewhere where it was bold and a larger font.
And I've actually been meeting with, actually we have a meeting set next week to meet with our our consumer unit to talk about the phone system and just making sure that all of our individuals are trained to answer those phone calls, and then finding processes to make sure that A, that we're answering the phone call in a timely manner, and B, that those phone call returns are getting returned. And just to give you an example, I actually tested them in the last couple weeks, and made sure that when I left my phone number, I did get a call back, and I was happened to report in 19 minutes I did get a call back. So, and it was from an unidentified number. They didn't know it was me. Shocking to all of them when I answered the phone, but it was actually a very good test from mine, because I know, we'd had comments on that last time, and I really wanted to thank the, Consumers Union for bringing those issues forward, and we'll continue to test that as well as start getting statistics on the hold time on the phone. So we want to make sure that if we're driving people there, that we're actually answering the calls and giving them the information they need.
Okay, so I'll stay here. Go ahead. Now, comments from my colleagues on the committee.
Just a question. Given the admitted shortcomings of the current website, do we have any statistics on how often that search function is actually clicked, the verify your verify license? Okay.
And Kim, should we roll into the website, or you want to just?
If you want, I can.
I think the question might be answered when we're doing a demo on the website. So that's why I like to take all this together. If you don't mind, it's probably easier. So if we could roll right into the website and then take questions. Okay. I know it's out of order, but.
So if you guys get ready. Okay, well, we went back after our last meeting and really did a look at our website, taking some of the information that had been provided from a lot of the members as well as the public on our website. And then, much to my staff's chagrin, started going and looking at other websites of others and using what I have thought of, like when I've gone to another board's website, oh, I like that, or oh, I don't like that, and kind of using that as a goal as well. So when I go to this website, it's difficult for me because I like pictures. Maybe that's it, I don't know. But I have a hard time even finding out where to go. I know verify a license was brought up last time, that might be confusing to individuals. But just on the face of it, when I first come to the website, I want to see exactly right up front where to go and what to look for. And I also want to call the public documents forward too. That's something that had been brought up from our public individuals, that, hey, one of the best places is to be able to go and look at our public documents as well, because it's an easy check. You can just go in and look at the last name. We want to drive people to our website as well, but that's another tool and resource. So I'm going to have the members, it's in your packet, but if you want to take us to the enhancements that we're looking at right now, the first ones. Whoops. Okay. So this is what we have developed, something right there on the front after our mission, that it states right there, okay, here's how to, and again, we're going with the theme of what Dr. Lewis had come up with on Checkup on Your Doctor's License. We're going with the same theme. We're going with the same picture, tie continuity together. Ms. Hawkinson has been really good about teaching us about branding. So we're trying to make sure that we have the same branding on all of our documents now and everything. Then the other thing is, sometimes that's not clear enough. So we've actually added a little bit of a blurb as to, okay, what does that mean though? So check up on your physician's license status with the medical board. And I know it looks kind of weird because we're saying doctor in the first sentence and physician in the second. And the reason we're actually doing that, we do have a method to our madness with the inconsistency. It's that when you actually get to the next page, when you go to search by a licensee, it's entitled physicians and surgeons, and that's what all of our information is under. So we wanted to put the word physician in there. So we also put the red check to tie in with the brochure called License Search. And then if you'll notice up over in the right-hand side, we've entitled that Verify a License to License Search. And Charlotte has actually done some data gathering from other boards. And if you want to talk about that a little bit, about the information that they have.
Yes, so out of all of the 50 states, about 15 of them still use the word verify a license or some version of license verification. However, the majority have moved over to look up a license or search your doctor, license search. So we went more with the main group.
And the reason we left it license search rather than like physician or doctor search is because that button over there, although the main one we're driving for physician and surgeons, we still do have licensed midwives, research psychoanalysts, polysomnography. Of course, I had to choose that one, the hard one. But anyway, all of these other license types that we have. So we wanted to make sure that we're not, segregating from those individuals. So then the other thing we wanted to put on there is how to file a complaint. So that we wanted to make it bold on our webpage. And then the third thing is the public documents. And we wanted to put on there search enforcement documents for physicians and other licensees, because once you click on that, you can do the name search on the individuals and pull up the documents that we have available, if there are any available. So from this screen then, and we're going to actually, is that what we're ready for, to demo? Mm-hmm. Okay, so then we're going to actually demo what happens when you do the license search, and I think we're live here. So we've found a choice physician that we believe we can check up on his license. So this is what comes up next, and then you can see here it gives you options, and so we're going to choose physician and surgeon. Oops. And then there was a choice there from by name, by license number, etc., and we chose the by name. So,
Was there a word that said DO?
Actually, we put information on there to say if your license isn't found here, they may be an osteopathic. Good. So go to the there it is.
That's
so
it, yes.
Yeah.
Right. Good.
Okay. So there's your choices. So then you'll do search by name. And I think we're waiting. Okay, there it is. All right.
Who's your choice physician?
Probably you.
Of course you.
And I wasn't even scripted with that.
Right?
I said it's probably you.
I behaved. So I'm there.
So then it's going to pull up his information. And we might have a slow connection. And then from there, you'll have, we'll search. The one thing that is different, and I'll be talking about a little bit tomorrow, that we're working on another possible revamping of the license lookup, but with the Department of Consumer Affairs. In the old system, you used to be able, I believe, to see the location on that front screen. So that will be something that we're going to be asking for in any type of revamp of a system, is that up there, because usually, if you at least saw, I have, Ronald H. in Riverside, and I have Ronald W. in Sacramento, I know which one's probably my doctor because it'll be easier to locate them. So then this is the web page that comes up. And you can just scroll through it. Hopefully all of you have looked at our website, and for those of you that are physicians, checked yourselves out. And so all of this information is here for individuals. But what we did, we're ready to move on. So what we did is we took, actually, I think it was Dr. Levine, some of Dr. Levine's and Dr. Krause's comments from the last meeting, and we said, well, what we really need is we need to know what that information on that physician profile actually means to the public. And so we wanted to drive individuals to be able to see a sample profile and then to go line by line through what that means. And they can take the time, hopefully, to look at this. We'll show you the links of where we're putting it on the webpage. We're putting it on 2 pages so they can see to get to it. So we're putting it right there, physician profile descriptions, and then actually if you clicked on the what is and is not available on a physician's report, we're actually adding it there. So the physician profile description provides you with a guide to understanding what is displayed on the profile. So then once you go back here, then we've outlined at the beginning, and we kind of tested some individuals, like, what do you really want to know about your doctor? So we tried to answer those questions here. The profile includes information regarding their practice location, their specialties, that they're licensed, whether or not they've had disciplinary action. And so all of this information, we're trying to assist the individuals with knowing what is important for them and how they can be an informed physician. But more importantly, once you start scrolling down through here, and it gives you the instructions of how to do this as well in that opening paragraph. Then once you start scrolling down, so we can just do license number, Shar, if you want to start. Once you click on that, it's going to pull up a definition of what that means. So the public can easily go and see, well, what does that license number actually mean? We've tried to write it in the 6th grade level. We've tried to write it with something that will be interesting to the public. And so hopefully we'll probably be sending what we've developed out to individuals to actually look at that and make sure that what we think is understandable and not so bureaucratic is actually that way. But for each of these items, then we've done this. And then the other good thing we've done is you can actually, if we want to go to another one, Shar, so we can maybe do the license status. So license status is one where you can have numerous items under that license status. So what we wanted to do, when I first developed it, it was like this big laundry list, and nobody wants to read through that. So maybe you know that your doctor is canceled. Well, what does that mean? So you can actually go click on it, it expands and gives you the information as to what that license status means. So then if you scroll down like surrendered, once you click on that, it gives you the definition, but you'll notice there that there's also some hyperlinks. So then in order to help the public understand that, once you click on that administrative disciplinary action, then it takes you over into the definition for that. So it can drive the individual to understand even more about what that information means. So if you want to go back.
But in general versus the specific?
Mm-hmm. Okay. Right. And the other thing that we've done, if you want to scroll down, so this is the, oh, go ahead. No. Did I miss something? No. Okay. So then if you scroll down, we've even done it on the physician survey. If you want to click on one of those, we've tried to explain what that means. That's probably, go to, are you retired? So it's a little bit more information, and we're also trying to answer those questions before they happen. So explaining this does not necessarily correspond to the physician's status, which may not reflect retired in the fee-exempt field, because a lot of doctors are retired and they report they're retired, but they keep up their current and renewed license because they want to still, maybe practice just a few hours a week. So that's another item we have. So then scrolling down, and the most important one for physician discipline then is if you click on the administrative disciplinary actions. On here, you can see, first of all, we're trying to tell them if the words none found are listed to the right of this title, then no public disclosure is available. If the words are found are there, you can, followed by a number, you can actually click on the word found and then go to the URL link. So if you want to click on one of those there. The other thing that we've tried to tell them is that to know the reasons for the physician surrendering the license, review the accusation or decision by clicking on the URL, because that was the other thing. How do we drive the individuals to actually being able to read a lot of that information? And there might be some clarity in talking to maybe the Consumers Union group or other community groups as to maybe making that a little clearer. But that's kind of how we've put it out there to try to help them to understand where they're going to get that information.
When you're putting it out there for clarification for the public, I would recommend you go to a group that has nothing to do with the medical board, that has no understanding of what the medical board does, who's not had any issues with the medical board. Because that way I think you get a better perspective of what detail needs to be there.
It's a great idea. So that's kind of the update and the changes that we're proposing at this point for our website. So they all kind of tie together, from the campaign to the brochure and to the updates to the website.
Can I ask one question, Dr. Lewis, about this?
Go ahead. Yeah, I'm going to walk
This is absolutely excellent. I want to thank you guys all for doing this. My one question I have, the issue that I've had when I've tried to check the website with someone who needs help, is that not often the last name is correct, and the first name might either be spelt differently or spelt unbeknownst to me, that's how you would spell the name, or for whatever reason, and then I will get not found. So if there was a way to either instruct the reader or the opportunity to just take the last name and get a list, or the last name and a first initial somehow, that so that the person trying to get the information either gets a prompt or somehow gets further, you know where I'm, thank you.
And misspellings, if they can't find it, the other thing we can put in there is if they can't find it, that they can call the medical board, because sometimes we'll keep trying, different spellings and see if we can find the individual too. So.
And we'll be submitting a work authorization with the vendor of the Breeze system in order to enhance the search by name within a particular board, because right now you have to have an exact last name match. Like we put in Dr. Lewis's last name, it has to exactly match. It won't find anything starting with Lewis at all. So we're asking them to enhance that, so you could put in, Lou, and you would
get some
anything
prompts
starting with that. And then to also add that explanation of you can put in Lou and get Lewis in those.
Yeah, but it's the first name that I've also, that for me, it's been the first name more so than the last name.
Right. The first name will already do that, but currently you have to have the last name exactly right.
I can tell you that I wish that were true.
Okay, so I'm going to go around. We have agenda item 4, 5, and 6 combined into one. So I'm going to take questions from members of the committee first. So, Dr. Hawkins.
So I like the changes and the growth and development in this area. I do have a couple of questions and comments. I know that there are some patients in my practice who could do this very easily, but I wonder if we're going to take an opportunity to actually have a trial run with some. I'm going to have some of my patients try it. I'm sure some of them are going to get stuck because of their level of education, and get some feedback from them. So I think that's one thing I hope we'll do, is to do some trial runs and see where people are, some of the seniors, and where they get stuck, and have this as something that actually can grow and develop. The other thing is, one of the big groups, which you didn't mention, but is implied, is the churches. So in that low-hanging group of folks, people from the pulpit will talk about your doctor and this and that, and increasingly we're reaching out to churches to do health fairs and that sort of stuff. But I think a trial run with the consumer is really, really important, particularly some of the older groups who education level may not be as high as we think.
One of the nice things about the images is that if whoever we can get to pick up one of these flyers, we have, this stock photo in here, but we've used the same photo there. So anyone that picks up one of these and gets to our website, hopefully,
Right.
That
was all part of the branding.
Can get there,
To keep the.
So that was one reason why we used the same
Good.
image.
Any other comments, Dr. Hawkins? No?
I think it's fantastic.
Oh, yeah.
In the last 2 months, you guys, I really want to thank and compliment the people that worked on this. It's admirable, and I think it's going to move us light years ahead. Thank you.
Yes.
I'm sure.
Dr. Krause.
Congratulations on these efforts. They really are improvements. What are the metrics of our website usage? How many hits do we get? Is that increasing or decreasing? How does it compare to last year? So on.
Compared to last year, I don't have those stats available, but approximately last month, we received a total of 335,000 hits. 254 of those, 254,000 were actual unique hits to the site. So we do get, on the average, I think I did keep sorry, I have one stat here.
I'm probably responsible for 20%.
What does unique mean?
Oh, for the unique means the one-time IP address. So for me especially, this is what I do all day long. So every time I hit the website, that counts it as a hit. So for unique hits, it's registering your IP address the one time. That's a unique.
So if you visited multiple times that month,
It's only going to
count as one.
Right, but it still will count you a total hit page and then a unique hit. So
I think that's a great statistic, because it tells you that there's a need for it and people are finding it, and that it's worth our effort to optimize it.
we have a product called Google Analytics that allows us to track that kind of stuff through our website. And Cassandra Hawkinson has asked us to help her prepare some charts and things like that for future meetings. And we can drill down to the specific page and tell you how many people went through the search page, or how many people went to, this particular page, that particular page. So we'll be putting those together, helping her put together those stats, and future, meetings we can report on those individual pages.
To answer Dr. Levine's question, last month we had 91,000 people who clicked on the license search button here. So if they're coming through the traffic through the medical board's website, we can track it. The ones that we can't track are the ones that go directly to Breeze. So for the ones who came to our site first, we had 91,000 that looked up their
91,000.
Wait, you just entered into the conversation something I don't understand.
Oh, I'm sorry, she had asked a question
No, the
earlier.
Breeze versus help
The
here.
back door.
If when I sign on to medical board website
Right.
to verify,
Correct.
right, but doesn't that take me to the Breeze site?
Eventually.
Correct, but
And that Breeze site, you're saying, okay, so that's where I'm,
Go through
when you're on our
Breeze.
site, up in the address bar there, it'll say nbc.ca.gov.
that's what I go, right?
Once you click through and you get to actually out to Breeze, you'll see that changes the breeze.ca.gov.
Right.
The Department of Consumer Affairs owns that.
Right.
So we wouldn't have access to the
That
servers or to get the analytics out of there.
But it's coming, so that's just the second half of the same equation. It's not a new equation, it's the same.
There could be more hits that we don't know, but it's because of the avenue that they're coming in. They're coming in directly through Breeze versus coming in through our website first.
Because you could actually go to DCA's website and choose the medical board. Well, actually, that would take it to our website, but you could actually go straight into Breeze
Right.
and go from here, because actually probably I would say credentialing companies go straight into Breeze, not in through the medical board's webpage, because they can go and check all their licensees, not just, all of them that are on Breeze, but they can check more than one license type. So if you hit here first, we can't measure that.
But to get to that page, you haven't gone,
Yeah, so that 91,000 is the number of people that hit license search for us and went through find it by name that way.
And
if an individual just starts out on their computer and they go straight to Breeze or straight to DCA to Breeze, we can't get that number.
and who are the 335,000, where have they come from?
They've gone just to our website overall.
Just overall, in general, our website.
So everybody understands this but me, right?
Yes.
I'm glad.
We'll explain it to
I'll
you
have
later.
a tutorial later, okay?
We'll get a 12-year-old to explain it to her. It's always the kids.
That started with www.nbc.com.
So they may have gone to the form section or the index section or the outpatient surgery center, not to the verify.
No.
Through a different door.
Okay.
That's all pages.
It's everybody that's doing anything with the medical board. I thank you, Dr. Kraus, for clarifying my
So-
stupidity.
Dr. Levine?
Yeah, so the good news is that the majority of folks going in through Breeze or DCA are not consumers. They're more likely to be licensees. When you go to renew your license, it says check your profile. And so
Yeah, the only ones that would is if they are real familiar with that process and they just bookmark Breeze and they just hit Breeze every time. But again, that's probably not the normal public person. Yeah.
Anybody on this side, any comments? Then I'll go back around to make sure I've, anybody else? Okay.
I just
now,
have a comment about
Go ahead.
can we get demographic data on the click? Is that possible through age, ethnicity, gender?
You can get location, some details like that.
Okay.
But
Which will narrow down the zip code?
yes.
Okay. Because that would help.
I think it goes down to city and down to zip code eventually if you want to drill down that far.
Okay.
There are, some products out there that will allow you to add that extra demographic info, but it costs money.
Okay.
So, it's something if you guys are interested in, we can look further into it. It's not in the package that we currently have.
Okay, great. I think you guys did an excellent job in terms of answering the not so obvious questions with the click-through and the explanation. I think that's excellent.
And when we do enhance the website to have these new images, we call them tiles out here, just how we can tell how many people click the verify license button 91,000 times, we can tell you how many people come through these buttons too, so we can know if this is getting out and making a difference.
And that's also part of the reason that we're putting the what is that called? That QR code, is that we can start identifying pages to have these codes go to a specific page. So if we're trying to see how many people are filing a complaint through perhaps one of these brochures, we can get that data then too.
In the bottom left-hand corner on the back side, the little thing looks like a barcode. You might see a product in a grocery store or something like that. That's called a QR code, and your cell phones, you can scan that code, and what this blob actually means is it's a pointer to the medical board's website. So if you have the functionality on your phone, you can just scan that and it takes you right to our website. And so we can add those to any kind of publication that we put out now. And people that know what they are, they see them. Other people just look right past them. But it's
Again, it's age specific. I guess if you're over a certain age, you wouldn't know what it is.
It's a handy tool because our website
Specific ages.
But if you can just take a picture and pull off that website, www.nbc.ca.
I think we're all going to have one of those right here eventually, right? So go back around, Dr. Levine.
Yeah, just a couple quick comments. One, I don't know if I'm the only one who's surprised. I think 91,000 is a lot more than I expected the answer to be, so I think that's very reassuring. And the other is, I think it's that Google Analytics will be incredibly important in being able to track spikes based on specific activities in this outreach campaign. We'll be able to, we ought to allow enough time to actually measure the impact of a PSA or a health fair locally to see whether we're getting spikes. I think it's great.
Right, we do that each month. So I do have the sample Google Analytics that we pull each month. It can tell me the language that they're speaking. It breaks it down: English, French. So it's pretty detailed.
And right now, we're including them on our Ms. Hawkinson's PAO report, but it was a great idea to actually put it in a chart, by month, so we can actually track it and see what months we have spikes and everything. So
We can probably even track news articles out there. If somebody's, concerned, or there's some terrible thing happening, we could probably see a spike maybe. But it's a great tool.
We put out one of our news releases and send it out through the subscriber blast. You can see instantly.
Can you?
It spikes up that day with people coming into our site to read that news release.
Good. Well, any more?
Wait. So when you put out you put out some kind of a subscriber alert, you click on that subscriber alert to find out what the subscriber alert is, and then you're counting that as a click onto the website?
Because that link in that subscriber alert takes you back to our website.
To some place in the website.
But not if you just read the article? Okay.
And on our site, we'll be talking about this actually in the next committee, but the subscriber alert, it'll come up with the name of the doctor, what he did, and then you can actually click. It actually clicks into that public document, so that is hitting our website.
It's amazing, just amazing.
So you want to hear amazing? I'm going to tout what Sean, in the future, one thing that's interesting is if we can, for those that are high-tech, you could actually Dr. Lewis could actually have a QR to his actual license page. So one of those little things on the back. So in time, if we get, everything kind of like the way you'd like to in the future, working with DCA and license lookup, you would literally be able to, if you wanted to have on your forms, you could have a QR that goes directly to his license profile. So,
I work in the prison. I'm not sure yet. I'm not sure I want that just yet. But
we won't pay for those
someday. So we need to move on. So I've heard from people to the committee. My prerogative, if you don't mind, is since we've talked about agenda item 4, 5, and 6, I'd like to combine them all, if you don't mind, because they're all related. So what I'd like to do is I have public comments here, and most of them are.
Good afternoon. My name is Marian Hollingsworth. I'm here on behalf of the Consumers Union Safe Patient Project, a nationwide campaign that is organizing patient safety advocates from across California as the California Safe Patient Network. We are pleased that the MBC is recognizing that its mission regarding patient safety includes its responsibility to support consumers in knowing the history of disciplinary actions of the physicians they are considering seeing for their care. We have reviewed the board's appropriate renamed Check Up on Your Doctor's License campaign outreach plan. We would like to preface our comments regarding the signs in physicians' offices by noting that we believe that the most effective and efficient way to notify patients of their physician's disciplinary history is for physicians who are on probation to notify their patients of their probation. We recommend some straightforward edits to the sign that is already required by statute and regulation to be posted in physicians' offices and in all places where doctors practice medicine. The current sign says, "Notice to consumers, medical doctors are licensed and regulated by the Medical Board of California," and it gives the phone number and website. But this sign gives patients absolutely no indication that the medical board is the place to file a complaint, nor does this sign indicate that the medical board is a place where patients can go to find out whether their physician has been disciplined. Changing the sign is something more effective that would cost the medical board virtually no money. But unfortunately, the board's outreach plan up to now has completely overlooked this potentially highly effective approach. We would support a revised sign that clearly states where to look up their doctor's history and where to file complaints against doctors, including an address, link, and phone number. Something like, if you want to file a complaint regarding your physician, go to www.mbc.ca.gov and click on Consumers Complaint Information. Or also click on Look Up a Physician to find out more information about your doctor's disciplinary history. In addition to a requirement that a sign be posted, physicians should also be required to ensure that every patient who visits their office is handed a piece of paper that includes the information we just proposed to be included on this sign. We would encourage the board to attempt to make these changes by regulation. However, if the board does not believe that is feasible, we urge the board to sponsor legislation to approve the effectiveness of the sign. And as a side note, as far as notifying the public, you may want to contact the school boards because all high schoolers are taught CPR and the Heimlich. They're required to have a little health card before they graduate. And this would be a great target audience because these are very tech-savvy kids and then would take that information home to their families. These are kids who are either going to go off to college, being on their own, or go into the workforce, and this would be a great way of reaching out to people.
Thank you very much for your comments. Appreciate it. Our next speaker is Lisa McGiffert, Consumers Union. Ms. McGiffert?
Good afternoon. I'm Lisa McGiffert with Consumers Union Safe Patient Project. And first, I want to express our support for the work you're doing. It's great to see the board interested in improving the outreach, and we support what you do, what you're doing here. And we know that your goal is to get people to know whether their doctor's license is in good standing, and we also think that people need to know when their doctor's license is not in good standing. And as mentioned before, we feel the most efficient way for that is direct notice from the physician to the patient. But when we're talking about the outreach plan on the website improvements, we very much like removing the verify the licensed issue. And we strongly support a robust website. And I think that your plan goes steps forward to making that happen. So when patients are looking to see if their doctor has been disciplined, we have a few suggestions. We have 3 ideas. Top of the page notice, when the patient gets to the profile, to have a statement at the top that says that this doctor has a disciplinary order or has been disciplined. We've been doing website reviews around the country, and we have found one state that does that. It's like in red. It's not like bold, but it's just in red, and that could direct people to look up the disciplinary actions. We're also recommending that there be a summary of the action. These board orders are sometimes long, very legalese, and we think a summary that would describe the action, the reason for the discipline, the timeline for probation, any practice restrictions, and it could be readily visible in the box where the actions are. We also recommend a monthly update of the list of doctors on probation, similar to the list that was given to Consumers Union when we did a public records request, listing the doctors by county so they could easily see, the public could easily see who is on probation, and put that list on the website as well as a link to that in your to your email list. We would like to see a budget for your outreach plan. We're a little concerned about the cost of some of these things and your strategy to coordinate with DCA. And we're really concerned. One of the cheapest ways to get information out to the public today is through social media, especially Facebook and Twitter, where millions of people are communicating each day. Not including a social media plan in this outreach plan is a glaring omission, and we think that you could probably do this very easily even with some interns. We encourage you to have the work ongoing, not just 1 month. And also, we're very glad to see you keeping up the statistics and hope you will use those for measuring your progress from time to time, and suggest that you try to get a polling question to ask if people know about the medical board, so you can test it a year from now to see if they do.
Thank you for your comments. Thank you very much. Next speaker is Ray Gerlich.
Hi, I'm Ray Groylick. I'm a member of the Safe Patient Project, and I want to really applaud your campaign. You've really done some wonderful work here and pretty much stolen my thunder. You're way ahead of me. So my testimony will be very brief. The creative strategies relying upon paper documents are great opportunities to reach that segment of the population that we're so concerned about, excuse me, that doesn't have internet access. And just to emphasize how important this is, you might want to add perhaps a hotline number, maybe a dedicated hotline number for just that purpose, to direct these consumers to get their information there. Just to justify how important this is and how big a segment of the California consumer population this is. You know, the Pew Research Center has given us some statistics, and I have compiled those against 2014 consensus figures for California. According to Pew, 39% of adults over 65 don't use the internet. In California, 13% of our population is over 65. 33% of those with less than a high school education don't use the internet. 19% of Californians don't have a high school education. 20% of African Americans don't use the internet, and that's 6.5% of Californians. 18% of Hispanics don't use the internet, and a whopping 38.6% of our California population is Latino or Hispanic. So we're talking about an enormous segment of our population. So I think this deserves more than just a bigger font on the phone number, on a pamphlet. I think that you know, you need to look at maybe increasing the emphasis of use of that telephone number and that hotline number. And as has been said before, not just for this 1 month, but going forward, targeting that segment, you know, protecting that part of our population would be real important. Thank you.
Thank you very much for your comments. The next speaker is Michelle Montserrat Ramos. Ms. Ramos, you have two, you want, just, can I just give her, 4 and 6 is perfect, so we'll get the two topics, two agenda items.
Good afternoon. My name is Michelle Montserrat Ramos. I'm here on behalf of Consumers Union Safe Patient Project. After reviewing your checkup on your doctor's license campaign outreach plan, I'm requesting that you expand your target audience to include the chronically ill, specifically patients, consumers who receive treatment in dialysis units, infusion centers, and cancer centers or radiation centers. These patients are the biggest healthcare consumers in the state, have the most doctors and specialists they see regularly, and are hospitalized more than the average California consumer. These patients are in the greatest need of the information you have available. For many of them, every decision they make is a life or death decision. As I spend 3 to 4 days in such a unit, I know that patients there excuse me, regularly receive information in the form of paperwork on a regular basis. They receive information on medication, treatment options, emergency procedures from their staff. The system's already set in place where you can develop one pamphlet or one flyer that provides information on who you are, what information your website provides to consumers, who your doctor is, and how to check his background, how to file a complaint, or even how to find doctors in their area by specialty. You don't have to provide a bulk amount of brochures, 1 or 2 brochures per unit. They make copies of all their pamphlets they hand out to their patients. You can reach countless California patients in one easy-to-do outreach and would make a significant contribution to making the most chronically ill aware of who you are and what your mission is.
Thank you very much for your comments, Ms. Montserrat Ramos.
Okay.
I have a
Item
one.
6. Did you want me to address
you
item 6?
Just combine them. That's
Okay.
good. Perfect. Thank you.
As you mentioned earlier today, we believe that most patients who actually find their way to the appropriate website page will have great trouble digesting the current content. When the patient finally reaches their physician's profile, if the doctor has been disciplined, a brief summary of the reasons for the discipline, the timeline for probation, and any practice restrictions should be readily visible to the patient and written in plain, easy-to-understand language. The brief summary should be located under the physician's name and license number. The patient consumer should not have to scroll through optional reporting information at the very end of the profile, which is long, to find a link to a public document, as most patients, consumers will not scroll that far. In addition to these important changes necessary to make the website content useful to patients, there are a number of problems identified by Safe Patient Project activists, which we understand are breeze-related, that need to be addressed if the board is to truly make this information accessible to patients. And I know that Kim mentioned about changing the verify license language, which is great. But I also wanted to look at the public documents links. I think there's 2 on the new example of your revamped website. And I know in one section it just mentions public documents. Another one it mentions enforcement documents. You might want to consider in parentheses adding, has your doctor been disciplined? Disciplinary actions, so that consumers will actually know that public documents is a link to enforcement documents or disciplinary actions. If we want patients, consumers to be informed, you need to give them access to your information. We're requesting that an additional search entry is added to the physician profile search. We're also asking that the search be changed to include a multiple entry search. We're requesting that a physician discipline search entry be included on the physician profile. With the additional search entry and the multiple search capacity, a patient can search for all doctors in a city such as Pasadena who have disciplinary records. So a patient can find out firsthand which doctors in Pasadena have public reprimands or on probation. The multiple entry search would help patients find doctors by discipline in their city. You could add a special entry to the search so patients can search for all cardiologists in Huntington Beach. I know that we can give consumers more information on their doctors, on the internet, and in person to fulfill your mission and commitment to protect California consumers. Thank you.
Thank you for your comments, Ms. Montserrat Ramos. My next speaker is Karen Ehrlich. Good afternoon.
Hello.
Hi.
Karen Ehrlich, licensed midwife. Hello. I also think these are some great improvements, and I'm glad to see that these are happening. I have 3 suggestions as we went through the presentation. The license search brochure, given that I am a licensed midwife, it's always a feeling of being a little left out of things. I would love to see another line somewhere on that brochure that licensed opticians, I don't remember, the somnographers, all of us, that these are also professions that can be, information can be accessed at this website so that it's out there. We want to be accountable to our consumers as well. I want licensed midwives on your brochure. On the field that shows all of the different disciplinary possibilities with the definitions that are on there, I had to notice that you have malpractice judgment and malpractice settlement separated from each other so that they're really in different places. I think they should be right next to each other with reference to each other so that in the definition it says this is different from a judgment. Click here to read what a judgment is. And on the judgment field, this is not a settlement. Click here to see what the settlement definition is. I think it would make it easier for people to understand what the differences are. Then in terms of outreach, it struck me that among the places where you might want to do some outreach is having to do with schools, as began to be mentioned, but parent-teacher associations, school boards, and I'm sure there are lists of private schools to be able to contact whoever their management are and executives to be able to get the information to the teachers and to the parents about this as well. Thank you.
Thank you for your comments. And my final speaker slip that I have is from Tina Mansouri. Sorry. Tina Manassian. Okay.
Good afternoon.
We can't read.
My name is Tina Manassian, and I'm a member with Consumers Union Safe Patient Project. We've come a long ways. You've come a long ways. I've actually been coming to meetings since 2005. I am a survivor of medical harm from a doctor who battled an addiction to alcohol, and he was on probation. Unfortunately, this wasn't available to me. Had it been available to me, I wouldn't have chosen him as my doctor. But I applaud you for all the steps that you've done to create this for consumers and to protect patients in California. But I have a couple of suggestions. One of them is, I don't know if the staff at Medical Board drives governmental cars or state cars. You could put your website on that. That's an idea. I work with seniors and veterans, and I do a lot of advocacy work out there. And one of the outreaches that I do is fairs like they do. I've actually seen one of your folks at a fair, and she did really well. I think her name was Miss Valine. Very informative. Another thing you can do, which I don't believe is illegal, you can ask Cassandra, an auto dialer. You're not selling anything, you're informing consumers in California. An auto dialer will automatically dial consumers and notify them of any public announcement you have. Politicians do it all the time. I get calls from both parties all the time. I hang up on them. Anyways. But I wouldn't hang up from you guys. And then one more tidbit. As far as a disclaimer, on your website under public, I believe it's public documents, it says, please read disclaimer. This section of the Medical Board's website contains scanned public record documents relating to administrative actions, blah, blah, blah. And then you go down to the bottom of that paragraph, last sentence, it says a search of this section only should not be relied upon to determine if a physician has had any action taken against his or her license or to determine the license status. Huh?
Triple negatives.
Yeah.
Syntax.
And so here's the issue that I had. My doctor had an accusation filed against him. But as I started coming to these meetings over the years, I found out that when a doctor is under investigation, it's not public record until it becomes an accusation. So consumers will never know that. So if you could put something on there, maybe in italic, not red, but maybe italic, maybe red and italic, but something that lets consumers know that there could be, if there's a pending investigation or a complaint against the licensee, this is not public record and it will not appear on our website, something like that. Because lots of doctors are under, well, Barbara just mentioned it today earlier that, right? There's investigations that have been going on for how many years? Consumers don't know that until it becomes an accusation, right?
I don't know about
Okay.
it. It comes to that out.
We need to, thank you for your comments.
Thank you.
Thank you very much. So quickly, we're going to go on the telephone for agenda item 4, 5, and 6. Anybody on the telephone?
Do we have any comments on the phone? John.
Hello, John?
John?
I guess John's gone? Okay, well, you don't hear anything, right? Okay, did I leave anybody out? Anybody from the committee? Okay. So we'll move on to agenda item 7, which is future agenda items. Anybody make a recommendation for future agenda items? Anybody in the committee?
Are you going to come back with a report as to what you, I apologize, Dr. Vino.
No,
it's your
it's
hand.
You've presented a tremendous amount of
Yes.
information, and I think, and got some great feedback, and I think it would be helpful just at the next meeting to have some report on a timeline.
Yes.
Because as I think one of our Safe Patient Project folks pointed out, to try and do everything all at once, would probably consume our entire budget. So what we're going to tackle when.
Right.
And just,
But if you look at the priority, we're going to do something priority, yeah.
I know, but those aren't all priority 1, are they?
No, they aren't all priority 1. They're priority 1, priority 2, and then good to have later.
But just the sequencing of the things
Right.
that are in that priority category.
Right. We've worked on that with staff.
So we were kind of waiting until we heard to make sure you all agreed with this campaign before we put timeframes, and we'll do like we did in the last one where we say what month we're going to be working on what in it.
And just if I remember correctly, and it wasn't reflected in the materials, March is National Consumer Protection Month, which was why we focused on that as the first out of the gate launch of this consumer education.
Right. I think because March is almost upon us in 2 months, we can focus what we can in a short time to get the stuff. We might not be able to do like the outreach to get them on the bottom of but everything we can do by that time, we'll focus on that.
And we're going to use that framing, the National Consumer
Yeah, we can look and see exactly what month that is and everything and figure out what we can do in that time frame. And
Okay, so for the next meeting, we're going to bring back some of this information. If there's any other data, if there's any other enhancements, we'll do a whole summary again at the next committee meeting, okay? Ms. Ehrlich? For agenda item? Is this for an agenda item?
This is for number 7.
Oh, yes, agenda item. Good. Thank you very much.
I'm trying to
You're fine.
play by the rules.
You are.
I would suggest also that the suggestions that the Safe Patient Project folks and I made about other things that could be added to this also be followed up on so that we can hear how what we've suggested is being addressed.
Yes, thank you. Copious notes have been taken, right, Kim? Yes, and recorded, so. Okay, so we've reached the end of the meeting. I want to give to Term Millennial or whatever, a shout out to the staff who has worked on this. Was there anybody on the phone? Did he ever come back? He never came back. Did John ever come back on the phone?
No comments, okay.
Okay, so no comments at all about any?
But did you not hear us out talking to you?
We're okay?
You were
Okay,
okay.
we're okay. We're okay on the phone. Okay, a personal shout out to Kim, Cassandra, and Jennifer, and the rest of the staff and DCA who have worked on this. I applaud you personally. Okay, thank you. And if there's nothing else to discuss, we will now adjourn the committee meeting. Thank you very much.
Thank you.
So you're staying for the,
Yeah, I'm staying for the next one. You don't have to, and you're neither.
30 seconds. Good afternoon, everyone. This is the Patient Notification Task Force meeting of January 21st, 2016. We are beginning this meeting at approximately 3:52 p.m. You may notice task force members accessing their laptops during the meeting. They are using it solely for the purposes of accessing information related to today's meeting. We have a designated time on the agenda for public comment and ask for public comment on each item. I ask that you be respectful of the need to conduct the task force business. Should anyone disrupt the meeting, I will ask that person to conduct themselves accordingly so we may transact our business. This meeting is available via teleconference. Individuals listening to the meeting will have an opportunity to provide public comment and will be assisted by a moderator who will be facilitating the teleconferencing process. For those members of the public participating via teleconference, please wait until the monitor has introduced you before you make your comments. To request to make a comment during the comment period, press *1. You will hear a tone indicating you are in the queue for comment. If you change your mind and you do not wish to speak, simply press the # sign. Assistance is available throughout the teleconference meeting. To request a specialist, press *0. During agenda item 2, public comments not on the agenda, the task force has limited public comment period for individuals on the teleconference to 20 minutes. In addition, public comment from individuals here at the meeting will also be limited to 20 minutes. Therefore, after 20 minutes, no further comments will be accepted. Business services staff will be assisting me with receiving the public comments via teleconference during this meeting. The task force welcomes public comment on any item on the agenda, and it is the task force intent to ask for public comment. I would like to request all speakers to complete a presenter slip so that I can call you out by name at the appropriate time and that there is a record of this meeting is full and complete. However, this is solely a voluntary request. Please give the speaker's slip to Ms. Lisa Toof. Ms. Toof, can you identify yourself? Hello, to my left. Thank you. I will do my best to call upon everyone who has supplied a slip for the agenda item and to recognize those who wish to make a last-minute comment. I would like to call this task force meeting to order. Ms. Toof, can you please call the roll?
Absolutely. Ms. Lawson? Here. Dr. Levine?
Here.
Dr. Lewis?
Present.
Mr. Serrano Sewell?
Present.
Thank you.
We have a full quorum. Thank you very much. On to item agenda 2, public comments on items not on today's agenda. I have no speaker slips. Are there any comments from the phone?
Do we have any comments on the phone?
Right now, no phone questions.
All right, thank you very much. If not, colleagues, let's move to the next agenda item 3. Okay. Agenda item 3, discussion, consideration, and possible action on the mission of the task force. On page PNTF 3-1, you will find the proposed mission of this task force. The mission and objectives were put together based on the discussion at the last board meeting and in my conversations with staff and attempting to summarize the intent of this task force. The objectives contain items the task force can explore in addressing this issue. So, colleagues, if you would take a moment to look at the mission statement, and here's and I want to get input from the task force as well. As you can see from the agenda, we're trying to discuss a lot of important issues beyond the adoption of the task force mission, I don't think at this meeting the task force would be required to take action on every agenda item. We could identify issues, have a discussion about how we wish to proceed, and then take subsequent action. Our normal course is when we have a motion, we have public comment before the board takes action, a task force takes action. I think in this instance, if everyone is agreeable, we'll sort of take it item by item. Again, my intent is to get public comment on every item. But please know that we may do it after a staff presentation, after the discussion amongst the members, but you will have an opportunity to speak if you want. So for this first one, it's sort of, I'm hoping we can take some action on the mission statement, and we'll go like we normally do. We'll have a discussion amongst the members, make some changes, motion, public comment, then call the roll call vote. So if that's agreeable to everyone, if you have any suggestions, that's fine. Dr. Lewis?
Yeah, I have a comment about the mission and about some of the areas to explore. As you all realize, there's a lot of overlap with the previous committee, and so I'm wondering whether part of our mission should just state really what this task force can do and try not to overlap with what another committee is also already doing. What are your thoughts about?
There will be some overlap, and I think both committees, the task force and the committee can inform one another. We don't operate in a vacuum. We'll be giving the full report to to our colleagues at the board, right? So they can have their input as well. So I think for starters, let's just take it on a case-by-case basis, but let's be mindful of that. That it's not the board, it's not this task force desire to, intrude on the work of other committees, but we recognize that there will be some overlap.
Okay.
Dr. Levine?
A couple comments. One, in the mission statement, I think what we want is something a bit broader than just physicians on probation. And I think it might be, as I read through it, it seemed to me that we want to explore methods to address concerns regarding patients, it's hard for me to wordsmith in the moment, but basically disciplinary actions, physicians who have been disciplined by the medical board, rather than narrowly focusing on physicians who are on probation. Physicians, regarding patient awareness of physicians who have been disciplined by the medical board. Now we have, I think, a permanent look back on some physicians, a 10-year on other disciplinary actions. And so it isn't just physicians who are on probation, but we want to increase access to information about disciplinary actions or physicians disciplined by the medical board.
That's great. We've got it up on the big screen now.
And one other thing, I think under objectives, we ought to move up. Part of our objective is to report back to the board with recommendations for consideration for approval or action. That's part of our objective.
We'll move that to the top. Are there any suggestions from the members? I think this accurately summarizes the board's intent with Dr. Levine's suggestions. Dr. Lewis?
Do you think the mission statement, I don't really want to keep wordsmithing.
No, please. Let's spend a few minutes on it.
It's like the mission of the Patient Unification Task Force is to explore best to address concerns. It's not addressing concerns, it's getting information out there. When I look at the address concerns, I don't know if that's the focus, just allowing patients to be informed, make an informed choice, and having the physician record is part of that. It's this word, address the concerns regarding, I don't know, somehow that's a little too vague.
I think it captures.
Captures it?
I do.
don't know.
So perhaps what you're looking for is a preamble.
Yes, a
that
preamble.
says the task force was formed in response to concerns raised about the challenges patients have in understanding the mission of the medical board or the work of the medical board and its mission, and B, finding information about physicians who have been disciplined. Then the mission of the task force is to address the concerns raised and propose solutions to the board.
Right, that's where I was getting at. But you proposed it very eloquently.
Got it?
Got it.
That's why she's on the committee.
Thank you. Thank you.
Can we, I think we can do this, but Kimberly, do you have any thoughts?
I was just clarifying with Dr. Levine's comments. Were your comments to the mission or to the first bullet of the items? Because kind of going back to what Dr. Lewis said, if we change it to methods to address patients' awareness of physicians with disciplinary action, then it doesn't have that concerns in there, and that's kind of at the heart of, I believe, what the mission of the task force is. Would that address everyone's concerns, both Dr. Lewis's and Dr. Levine's?
I think the preamble idea is a very good one.
Right.
Okay.
Yeah,
That's what you're getting at.
The mission with as you sort of stated.
Okay.
And then making some changes to the objectives.
I'll volunteer to work with you on wording that we can.
Thank you.
I was going to volunteer
And
you too.
we'll get to the public comment, absolutely. And what we can do is direct the task force to work with Kimberly in having a revised statement to the full board for their adoption tomorrow. Taking into consideration everybody's thoughts, right, and we have a clear idea of the direction we're going in, I think, right now.
And we can have it tomorrow
And-
available for the members.
Right. Would that work?
Still subject to edits.
It'll work if you have a language approved today. Otherwise, you can't continue to work after this task.
No, it wouldn't be. It wouldn't be. It would be to capture what was said in today's task force meeting. But I don't want to get into the weeds of wordsmithing it if we.
So what you're saying, Carrie, is we'd have to wordsmith it. We'd have to come up with language and vote on it here to present it to the board tomorrow.
Right. If what you're trying to say is you're going to present this language that you want the full board to adopt, then it has to occur at this task force meeting.
Okay. All right.
Okay.
That's fine.
Good luck.
If there are no additional comments from the task force, if there's members of the public that wish to comment, I do have some speaker cards, and if they're not on this particular item, let me know. But I have comment cards from Lisa. This was for item 5 and item 6. But did you want to talk on the first one, Ms.? Okay. Well, why don't we start to my right, and then we'll have you, Lisa. Thank you. Please. Doesn't matter. Thank you. Good afternoon.
Good afternoon.
With Consumers Union Safe Patient Project. And it seemed like this is the right time to talk about what we want to talk about. And to remind you that this task force was created after a petition was filed by our organization to require that all physicians on probation disclose their probationary status to patients. And we would like to see the task force focus be on this population that continues to practice medicine while their licenses are being monitored because of their behavior. And during that discussion of that,
during the discussion of that petition, many of the board members expressed concern that the proposal was too prescriptive and that the proposal failed to consider that some doctors are on probation for minor accusations. So while we don't share those concerns, Today, we're bringing an alternative approach to you to consider as you work through your, do your work, and urge the board to adopt it. We recommend that you amend the Manual of Model Disciplinary Orders and Guidelines to require as a standard commission that physicians whose probation is associated with certain serious violations that indicate a threat of potential harm to patients, that they inform their patients of this probationary status. We specifically have a list of doctors that we think should be this should apply to, and I can provide you that list. But they include gross negligence, sexual misconduct that requires a chaperone when they are seeing female patients, repeated negligent acts, repeated acts of inappropriate prescribing of medicines, controlled substances without medical exams, drug or alcohol abuse, and that's connected with during practice, and also any drug or alcohol abuse that requires regular drug testing, felony convictions, people who have reoffended while on probation, and people who've been placed on probation repeatedly. That's not the full list, but we feel like there are some that are definitely more serious than others, and we're asking you to require, as a standard of probation, that those people advise their patients in a manner that follows your disciplinary order guidelines number 26 with a log. And we also ask that that log include patients to sign that they received the notice. Thank you. I may want to talk on another subject later.
Absolutely.
Thank you.
Thank you for those
I
comments.
have copies of the proposal if you don't.
They were forwarded to us, I believe,
Okay, I
but
thought
you can
so.
at least
Thank you.
appreciate it. Ma'am?
The medical board, in the interest of patient safety and choosing a physician.
Karen Ehrlich, licensed midwife. Hello. This is a technical comment. My understanding of mission statements is that they must be one sentence long. That they may be long sentences as long as they are understandable. They can have semicolons, but they can only be one sentence long. Goals and objectives are there to flesh out what the mission statement is. I don't know about a preamble. I've never seen a preamble in a mission statement before, and you might choose to ignore me, and that's okay. I just wanted to let you know that that is the general feeling about what mission statements comprise.
Thank you. We're going to have, are there any other comments from the public? Well, those comments were helpful. And what in speaking with council, I'm thinking of a motion that would assign Dr. Levine to work with our executive director in making refinements to this mission, to this statement, for presentation and adoption at tomorrow's full board meeting, taking into account the tenor of the discussion this afternoon.
Right.
Preamble, the objectives changes, but I think we have a sense of what that looks like if it were to deviate. It's not further policy discussions between yourself and Kimberly. It is merely sort of to execute the discussion we're having today.
So can I I'll make that motion as stated?
Do public comment again.
I'll make that motion now.
Yes, please.
Make the motion as stated.
All right. Is there a second? Second. Thank you. There's a second. And being our practice, now that there's a formal motion on the table, if there's any public comment from the public present, now's your opportunity. Thank you. Seeing no public comment, is there any public comment from the phone?
We have a comment on the line.
Right now.
All right.
No
Thank you
questions from the phones.
Thank you very much. Ms. Toof, please call the roll.
Ms. Lawson? Aye. Dr. Levine?
Aye.
Dr. Lewis?
Aye.
Mr. Serrano Sewell?
Aye. Thank you very much. This was a good process, and I know I appreciate, and the full board will as well, and this task force. On to the next one, discussion on outreach to the public regarding physicians on probation. Ms. Kirkmeyer?
Thank you, members. We have a presentation here that we want to walk through because before you have any discussion on this, we actually wanted to walk through what currently is done when a physician is placed on probation. And really, in regards to Dr. Levine's answer, this actually would be for any physician that gets on disciplinary action. So it would be all the way from a public reprimand all the way to revocation, I believe, for all of these that we're going to be going through. So we thought it would be important to lay down kind of like the ground level work as to what the website has, what we do when an individual has disciplinary action. So then that will further your discussion when you hear public comments and kind of go from there. So the first thing that happens is we actually update the board's website, and that's that physician profile. For those of you that attended the earlier committee meeting, it would be this document here, and as you can see, we've actually made this a non-specific. It's Jane Doe. This really is not anybody. So Jane Doe here, you can see there on the secondary status, we changed that to probation. So before the action took place, it would have just said renewed and current, no other information on there. And so we add that probationary status, and then down at the bottom, that administrative disciplinary action turns into one found, or it could be more found if they had other action, but then that changes to found, and then what happens is, thank you, Dr. Lewis. So you see down here, this is where it would change here to indicate the action. And then once the person clicks on that, it takes us over to this document. This is kind of like what we call our public disclosure web page, and it will give the name. And then in here, it talks about the terms and conditions of that probationary order. So the public can actually see everything that has been attributed to that doctor and what they have to do. I think the next page actually has just this is just basically you'd have to scroll down on that, and we don't have that scroll because we had to put in Jane Doe. So, but if you looked at it, this would be the information that's there in that website. So that's the first thing that we do. And when I'm talking about what we do, we have a lot of things in the backfield that we do, but this is something that's available to the public. So all these actions now are things that are available to the public. Oh, right. And then we have the URL link right down here that actually then takes you to the entire record of that physician's action. So in this particular case, if this individual had just been placed on probation, it would take you to the stipulated decision and the accusation in this matter. If it's a proposed decision, it would just take you to the proposed decision on that matter. So that's the first thing we do. Then the second thing we do is we have a board subscribers list, and we issue a license alert. So on our homepage over on the right-hand side is a button that says subscribers list. You click on that and it takes you to this web page here. This allows an individual, anyone, to go ahead and sign up for what they want to see. So we have, I don't know, Shar, do you have any statistics on subscribers?
Not
okay.
About 2,000 that apply for just the subscriber for the alert.
Okay, so any individual, no matter who you are, can go out and you can click whatever you want to see from the medical board. We use this for our board meetings and regulations, but you can also sign up to get the activities of any disciplinary action, any action related to the doctor's practice, and then you put in your email address, and what happens, it's okay, go ahead. And then what happens is this email comes to the individual. So I'm John Public. I go subscribe, and when these individuals had action taken against them, this email comes to me, so I can find out about a physician. I know some of the issues have been, well, I checked my doctor once, but then I may never know again. Well, if you subscribe to our subscribers alert, our license alert, you would actually know if your physician went on probation later on. Now, you would have to obviously look each time you got this email, but at least it would provide you with information about individuals who have been placed on probation on that day or during that week. Okay. So the next item is actually a pending item, but I wanted to bring it up because I think it is tremendously helpful, and it will be. It's a Breeze subscription. So back on that license screen where I showed you when that license status had probation on it, we believe, and we're talking right now with the Department of Consumer Affairs, so this is pending and it's something we're investigating right now. But we're looking in, there is a possible ability that when you go into Breeze, you can actually sign up. So individuals that go in can actually make an account with Breeze. Then they would be able to subscribe to a licensee. And when that licensee's status changes, it will actually notify them. So this is something we're looking into. We're working with the department, but if this is something that's going to be available, this is a great impact, and I think something that you need to know that that's a possibility that's out there that we're looking into.
If they go delinquent, canceled, any status change, you'd be
right. And there is a difference between the primary status and the secondary status. We're looking into if it's only the one primary status or if it will also include the secondary. If it doesn't include the secondary, what our IT shop has planned is to put in a work authorization to the department to also include that secondary status, because we think this would be very helpful for the public.
What's the difference between primary and secondary status?
So, how do I describe this? So the primary status is really, can you practice? You'd have revoked, renewed current in there, delinquent. Let's see, I'm trying to think of all. It's the main license status. All of the others are added onto that. So you also have a public letter of reprimand. You also have probation, but your main primary status is still that you're renewed and current because you can practice. Does that explain it? It's kind of like additional information on the person's license.
The primary status more controls your renewal ability and the life cycle of your license, whereas secondary status are information like you.
Okay.
That you can set a profile. The primary status we refer to is the license status labeled there, and then you can have 0 or many secondary statuses listed after that.
So it's can you practice or not? The secondary is, are there conditions connected to your practice?
Right. That would probably be the best way to describe it. Okay. Then the next item is the newsletter. So each quarter, when our newsletter comes out, we actually provide information on the newsletter for the individuals who have had any disciplinary action taken against them in the last quarter. So here, we copied this right from our newsletter. So this is right there. We say where they're located, the action that was taken, and the date. And then in addition, recently we also added the link. So if you're looking at this online, which 3 of our newsletters are online, you would actually go right there, click to that, and that will take you to the document that describes the action taken against that licensee.
And we can have them subscribe to this as well.
That's right. And you can also subscribe to the newsletter. So each time the newsletter comes out, that you can go through and look at those. Okay. So then the next thing that we do, and this isn't really pertinent to patient notification, but we think it's important that you also are aware, we also send the information of that action to the National Practitioners Data Bank, and those who have the ability to have access to that can get that information. And then the next thing we do is we send it to the Federation of State Medical Boards, because they actually have an alert that notifies any state where that physician will hold another license. It notifies that secondary state, so then they can take action if they feel it's warranted in that state. And then the last thing, we really just want to again point out, because we know that there's an issue with individuals not having access to a computer, and we completely understand that argument and that issue. And we do want to make sure that everybody knows that our phone number is here. We have the 800 number that an individual can call. And I put on here available anytime. That's actually not true. It's available Monday to Friday, 8 to 5. So anybody can call during that time. They can either hold for an attendant or they can ask for a call back. So those are the ways that individuals can get notification. So from there, I'm going to kick it kind of over to the task force to discuss those and see if there's any other changes that they would like to recommend.
Dr. Levine?
So this is very helpful, and it suggests to me there may be an opportunity for the physician, the patient, the Public Outreach, Education, and Wellness Committee to follow the first wave of checkup on your doctor's license with a subscribe campaign. Once you've been able to confirm, because I think the primary license status alone doesn't give a whole lot of information, but if in fact we get to the point where a BRIE subscription could actually identify primary and secondary, we could have a simple campaign of, how to subscribe, how to get information on an ongoing basis about physicians you are seeing or you may be interested in seeing, something like that.
And that's actually something that Ms. Hawkinson really is targeting now when she gets calls from individuals in the press or anything. Hey, you can go out and subscribe to this. And she's really been talking when she gets callers as well to the media, because then that also alerts them. So this is something that we completely agree with, yeah.
Are there any additional comments from the task force members? No? Any comments from the public?
Right now, no questions from the telephones.
Oh, thank you. Julie?
Thank you. Julie D'Angelo, Falmouth. Is this on?
Yes, it is.
Thank you. I think what confuses people, Joe, normal consumer people, is when they go on the website, or on Breeze, and you look under, what does it say, primary license status, and it says renewed and current. I've seen doctors whose record underneath renewed and current says probation, suspended, cease practice, other stuff under there, but you don't get there because it says renewed and current. And I guess what I'm suggesting we think about is maybe you put probation, in that case right there, in red. Some other boards do that. If there is disciplinary action, it's highlighted in some different color to give you a sense of, oh, okay, there's a flag here, I need to check this out, and then I can make the decision whether I want to go there or not. But the way this is set up, and maybe it's necessary, license renewed and current often doesn't lead me to go any place, to look beyond that, below that. And that causes confusion.
Thank you. Are there additional comments from the public? Seeing none, are there any comments from the phone? This is on item 4.
Any comments?
No question currently.
Okay, I don't see a motion here for this one. No, this was a report. Thank you very much. Again, we've taken a lot of notes, and that'll be included in a report to the board that the task force will publish after today's meeting, after tomorrow's meeting. It'll happen soon, but not in the next 48 hours. Anyways, on to item 5, discussion on information available on the website regarding physician discipline.
So the same kind of concept. Again, we just wanted to walk through the website and let the members know what's available on the website as well. So, and the couple of these are going to be really short because we've already talked about them. But obviously on any physician's profile, once they go on probation, that information's there, the document's available to the public. So the next thing is the newsletter. Again, we also, and the reason I put it in both places is because to let everybody know it doesn't only go out when it first happens, but then those newsletters are held on our webpage. So if an individual wanted to go back to, 2 years ago and see what disciplinary action was taken in that quarter, they can go out and look at it. But the third thing, and I know this has been brought up a lot, but the enforcement public document lookup is a invaluable tool to me. I almost use this on a daily basis. And what you do is once you get in from that home page into the search, you can actually type in the physician's name. So in this instance, not to put anybody under the gun, we just put AM in. So we pulled up the whole list of documents for the individual with AM. And especially with the passage of AB 1886 that happened last year, now all documents that were an individual's on probation, those will always remain on their record. In the past, it was only there for 10 years, but now it's there forever. So once you go there, you can actually look at that list, click on the link there that will provide you once you scroll over it with the highlight, and then it will go to the actual document for that physician. So we think that this is a helpful tool for the public because you don't have to look at anything else. If you're just really looking, do they have any enforcement documents out there for them? Here is the information. And the reason we say, which we do need definitely to clean up that sentence, but the reason we say that is because we also want to encourage everybody, also look at the physician's profile, because there might be information there that you won't see here, such as action on a felony conviction could be there while the case is ongoing, but at least you'd know the felony conviction, there was something there. So we also want to drive them to the patient or the physician profile. And then the last thing, and this goes actually to a comment that was made earlier today, and I don't think a lot of people maybe know this is out there, obviously, and so we also have a disciplinary action license alert page. And so if you go from our web page, so if you go to publications and down, if you look at disciplinary action / license alerts, you can click on that. And I'm not going to walk through there, but there's the years, and then you can flip over to the other one, Sean. What happens is once you click on that document, This pulls up a list of all of the actions that have happened in that year. And for like, if we pulled up, we only have 2015 on here. So an individual could go out there and look. Here's the name of all of the actions that have been taken in the last year. So if they wanted to go there, it comes up in Excel. So if you wanted to search your doctor's name, now it's only for that year, and that's only the actions that happened in that year. You can actually search and find out any physicians that had in that time frame. It does have the city. So that was something that an individual brought up. I'd like to see all of the individuals. Again, it's only for that year, but they can definitely do a search by city and pull up the information of all the doctors in that year that had action in that certain location. So this is something that's also out on our webpage. Anything I'm missing on that? No. This actually, just to give you a little bit of history, we used to actually do a hot sheet that we would provide to individuals, and this was a follow through now when we started doing the alerts that we actually put it on this hot list. So those are all of the information that is available on our website to indicate an individual has had disciplinary action.
Dr. Lewis?
Yes. Question. The pending cases that are pending from the AG or whatever, you can look that up internally, right? You can't look that up public, and I assume it's because if the case isn't closed, it could be expunged, or it could have a better outcome, or...
Actually, that's a great question, and I'm glad you asked that question, because there's more to this story than meets the eye about what we post on our website. So the medical board is probably one of the largest statute-driven individuals of what we can post on our website. We have two sections of law, 803.1 and Business and Professions Code 2027. Both of those sections of law drive everything we can maintain on our website. Just like earlier, the paragraph that was discussed, we'd like to have a paragraph on the physician's profile. Any type of change like that outside of what we already post on a physician's profile would have to go through a legislative change. So for example, one thing we do say, and can you go back to our lookup and get to what is and is not? One thing that we do, Dr. Lewis, though, we do want to let individuals know what they can and can't find on our webpage. So if you go to our one page, so right here it talks about under California law, the following information is confidential and not public and would not appear. So you see complaints, investigations, and then the misdemeanor convictions and some medical malpractice information. So we want individuals to know you can't use our website to say that there isn't anything pending, because these things might be available, but by law we can't post any of that information until an accusation is filed or an interim suspension order.
Okay, because there was a comment earlier about just put everything out there, even if it's pending, but what if the pending case gets thrown out and there's no action, then you've labeled this,
and
we
that's
don't put any
exactly,
of that, so,
and
right.
again, it goes to what the law says.
What the law says, that's, thanks.
For those reasons.
Yeah, that's what I wanted you to clarify, thank you.
Perfect.
Thank you, Dr.
And then there's one more document. It's a long and convoluted document, I have to say, but we want to make available everything so an individual will know when the information is available, because we do have, because of our law, we have one law that says what is public, and some items hold to a government code section even, and then we also have the law under 2027 that says what we can post on our website. So we provide this document out there to let individuals know. So for example, a court-ordered restriction, it's only available while that person is basically under that court order restriction. However, it's always public at the medical board. So if you made a call to the medical board or you walked in, that information would be provided to you if you made like a Public Records Act request. Just like a public letter of reprimand now, it's only there for 10 years. Although it's only there for 10 years, the document is indefinite, but it's just that it can't be posted on our website for more than 10 years.
So I just want to understand what you can and can't change. So that paragraph on disclaimer, you're saying that's...
No, we can change it. I'm talking about on an actual physician's profile.
Oh, okay.
Any addition to information there would have to go through a statute change.
Sure.
Yeah.
So as you're going through all this, after 7 years on the board, I got lost. And so I wonder whether we ought to think about something for the website that in the format either of a Q&A or a narrative that explains in eighth grade literacy level, if you want to learn this, here's how to find that information. If you want to learn why, either a Q&A, how do I find out, how do I learn whether my doctor's license has been disciplined, or or some way for the average person who is not a regulator, it isn't even a licensee or not a regulator, to be able to navigate what is obviously a wealth of information, but not terribly accessible. And the other thing that strikes me is that none of us in this room are average consumers, and so giving people information that is useful to them, there's a point in time when there's a desire and a need for information, and when you inundate people with information when it's not high on their priority list, it doesn't stick, they can't use it, and it's just an annoyance. And so figuring out how to respond to an interest, a need, and to some extent stimulate interest without assuming that the 30 million people in California think about us every day, even think about their doctors every day. And so making the information as easy as possible to access without assuming that everybody wants all of it all the time. And I think that's all of our challenge in our day jobs, actually.
Definitely a task for Ron's committee.
Yeah.
That's a
and actually,
serious
I
issue.
think the tutorials, if we,
like the fact sheet idea.
A fact sheet and a tutorial, if we can actually do video, even a short snippet video, that's where we really want to go, because I think those are easier to watch rather than reading this big prose document. And so maybe we can actually think of some other ways, like if you want this, and then you can just have a talking head even, or, some examples of how to get into the website, some tutorials. That might be something we can look at as well. It's just outlining it to where it grabs their interest to want to click on that and understand it.
It's so helpful if we had the ability to do focus groups. Of different groups of consumers to understand what are their highest priority interests and needs, and when would they want that information.
Okay. I do have a speaker's card for this item. Ms. Ramos?
Good afternoon, board members. I'm here on behalf of Consumers Union Safe Patient Project, and we're pleased that you're taking steps to ensure the website is useful and effective for consumers who want to know more about their doctor and understand their doctor's disciplinary history. As mentioned earlier today, we believe that most patients who actually find their way to the appropriate website page will have great trouble digesting the current content. When the patient finally reaches their physician's profile, if the doctor has been disciplined, a brief summary of the reasons for the discipline, the timeline for probation, and any practice restriction should be readily visible to the patient and written in plain, easy to understand language. The brief summary should be located under the physician's name and license number. The patient consumer should not need to scroll through optional reporting information at the very end of the profile to find a link to a public document, as most consumers will not scroll that far. Now, in mentioning what Kim was just talking about, it's really interesting. I spent a lot of time on your website. I've never seen that document. Now, I mentioned this earlier with public documents. It's shown twice in your revamped website, and a lot of consumers aren't going to know that that's going to lead to disciplinary actions. So if you could, in parentheses somewhere in really plain language on both links, listed, has your doctor been disciplined, disciplinary actions, etc., and so consumers will know that that public document is going to lead to disciplinary actions if there are any. If we want patients, consumers to be informed, you need to give them access to your information. And that was an interesting document I just saw, but I still think it would be easier within the physician profile if you added an additional search entry, which would be a physician, in the physician profile search. We're asking that the search be changed to include a multiple search entry, and that a physician discipline search entry be included on the physician profile. With the additional search entry and the multiple search capacity, a patient in the physician profile can search for all doctors in, like, let's say, Pasadena, who have disciplinary records. So you could find out firsthand which doctors in Pasadena have public reprimands or are on probation. The multiple search entry would help patients find doctors by discipline in their city. So you could add a specialty entry to the search so patients can search for all cardiologists in Long Beach. I know, and you're making great strides, I appreciate it, but I know we can give consumers more information on their doctors, on the internet, and in person to fulfill your mission, commitment to California consumers. Thank you.
Thank you for your comments. Other additional comments from the public? From the members present? Public present? None? Thank you. Any comments from the phone?
No phone questions.
All right, thank you very much. Again, this was a discussion item, no action taken. On to item 6, signage required pursuant to Business and Professions Code, Section 138. Ms. Kirkmeyer?
At the last board meeting, a number of comments from both the board members and the public were received regarding the signage that is required in either a physician's office or in certain documents provided to the patient. The comments centered around the language on the notice and the fact that more information wasn't provided, such as informing the public to check on the physician's license status or that a patient should file a complaint about the physician with the medical board. The intention was that it would cause the patient to go to the board's website and check the physician's status to see if he or she was on probation. The regulations requiring the signage was required based upon Business and Professions Code Section 138, which states that in part the board must adopt regulations to require its licentiates to provide notice to their patients that the physician is licensed in the state. And I believe in your board packet, and it's up here too, is that section of law. This statute is the authorization for the board's regulations. Although at first it would appear that this legislation may be broad, and the board could amend the signage to include more information, upon a further review of the legislative history, our legal counsels have determined that the language is actually very narrow. I will ask Ms. Webb and Ms. Dobbs to speak on this, but this information will limit what the board can propose in a change to this sign, and I wanted the members to be aware of this prior to initiating this discussion. However, the board may look at amendments to the sign, and rather than go through the regulatory process, either bring this issue up in the board's next sunset report or seek broader legislation. Those are your options that you have before you, and I'll ask Ms. Webb and Ms. Dobbs for their opinion based on their legal analysis.
Well, like many of us, we were hopeful that we would be able to add some additional information required to be on the sign through regulation. But in looking at the legislative history of Business and Professions Code Section 138, in earlier drafts, the language actually was going to say that the licensee had to indicate whether his or her license was in good standing, and the means for contacting the board for the purpose of seeking information or filing a complaint. That language in the earlier drafts of the legislation was specifically stricken out, and that left a very bland authorization to boards for requiring what licensees have to put in their signs. So because this was in the earlier drafts and specifically stricken, it's our belief that a legislative change would be required, and we couldn't do it just through regulation. We don't have the authority to do it.
And again, that statute really just says that you can say that they're licensed in this state, so.
Dr. Levine?
Does that section of law apply only to medical board licensees?
No, this is boards throughout DCA.
So presumably any change to the legislation would apply to DCA boards, all DCA boards.
Yeah. And unless we made it specific to the Medical Board of California and put in our own section that said that we could do a sign that says whatever you want to propose.
Well, this signage question intrigues me because it is, by state law, an area that this board and the other bureaus and boards under DCA have some say on the real estate, what it potentially could say. And, you know, you see the bumper stickers on cars, how am I driving? Call this number. And having some additional language to that notice is an idea I think this task force should explore, and balancing all the interests. So perhaps at our next task force meeting, we could have a more in-depth discussion about that. We've had suggestions from the public about what it could look like. And I like your idea, Kimberly, if this goes anywhere, to include in our sunset report to the legislative body, should they decide in their own discretion to have this board continue, that it include the appropriate amendments and that reauthorization legislation. And they're the ones that drafted this one, so they'll have the legislative history as well. That might be the way to go. Are there any additional comments from the task force members? Any comments from the public? Seeing none, are there any comments from the phone? Oh, I'm sorry. Oh, ma'am, I apologize.
No comments or questions.
Ms. Hollingworth? We're going to take a public comment on item 6 from Marion Hollingsworth. I apologize.
My name is Marion Hollingsworth with the Consumers Union Safe Patient Project. Regarding the signs, I went over previously what we had suggested to add information about on the signs about using the signs as a way to tell consumers how to look up their doctors and also how to file a complaint that they can go to the medical board. I'd like to ask the task force and the medical board to sponsor legislation to allow the medical board to make changes to the signs so that consumers will be told they can contact the medical board for complaints or for how to look up their doctor to find out his or her disciplinary history. And on my own, as a consumer, I'd just like to say that the task force was formed after Consumers Union filed an administrative petition to require doctors on probation to inform their patients. Everything that has been talked about today so far has been putting the burden of finding out this information about doctors on the patients. No one on the board has said anything about putting responsibility on the doctors, the ones who got in trouble in the first place for not meeting standard of care. If you are concerned about the cost, the easiest way is to come up with a form that both the doctor and the patient have to sign acknowledging that the patient was informed that the doctor was indeed disciplined and on probation. If you are spending countless hours and dollars thinking up ways to inform the public, why not just take the easiest and most direct way to require the doctors themselves to tell the patients? I think the task force should consider this in addition to showing patients how to look up their doctors. Thank you.
Thank you for those comments. Are there any additional comments from the public on this item? Are there any comments from the phone?
No phone questions.
All right, then, thank you very much. We'll then move on to the next item. Ms. Kirkmeyer?
Okay. Well, although the board denied the Consumers Union petition at the last meeting, which was to amend the board's disciplinary guidelines, the members had discussed looking at alternative proposals to address this issue in the disciplinary guidelines. Prior to the members' discussion, I wanted to specifically indicate which conditions have some type of notification, so I'll be going through those. In addition, at the last meeting, I stated that there was only one board that currently had patient notification in its disciplinary guidelines, and that this board had not used the optional condition to date, and that was the Board of Optometry. I wanted to notify the members that at an enforcement committee meeting of the Board of Chiropractic Examiners a few weeks ago, that committee approved a proposal to add patient notification to their disciplinary guidelines. Now, this recommendation has not been adopted by their full board, but I did want to let the members know that it was a proposal that they were discussing. So going to your handouts, your document, if you look at the disciplinary guidelines and on page 21 of the document, these two are back to back. We actually have the third-party notification, and currently it's condition 25 of the board's disciplinary guidelines pertaining to a third-party chaperone has optional language that can be added to a decision requiring a physician to provide a written notification to his or her patients that he or she is required to have a chaperone. And then right below that, in addition, condition 26 regarding prohibited practices requires the physician to notify all patients being treated that he or she is prohibited from performing that procedure. And any new patients must be provided the notification at the time of their initial appointment. Now, both of these conditions require the physician to notify the patient of that specific condition, but they actually don't require the physician to tell the patient why they have this condition imposed. So the task force could consider making changes to the disciplinary guidelines, but again, any changes would need to go through the regulatory process. And I leave it up to discussion.
Dr. Levine?
Just a point of information, how many physicians on average in a given year are on probation?
So I think earlier today, Ms. Delp said right now we have 614, I think, so about 600, anywhere between 500 and 600 in a given year are on probation. And I believe it was either last year or the year before, I think we put about 122 individuals in that year on probation.
Are there additional comments or observations? Dr. Lewis?
And how many, to go on with Dr. Levine's comment, how many follow or, how many are in the categories of those two disciplinary guidelines, would you think?
Oh, I'm glad you added that, because I wouldn't be able to answer that without going back and analyzing it. But I would think that it was a very low percentage.
Low.
Probably, because it's a sexual misconduct case, which isn't one of our higher categories. And then the prohibited practice, that's, not that it's rare, but it's, maybe like 5 to 10% of the individuals that actually end up where they can't actually practice a specific function.
Procedure,
thank you.
Okay, so those are the only two categories where there's a disclosure
Right.
required by law to the patient.
To the patient. There's our notification to, other entities and their employers and everything,
those
but that's,
right, and those are very low numbers
I would think.
in your estimate.
Yeah, if you're asking me to kind of give a wild guess, I would think that these two are probably low.
Thank you.
Christine?
On the prohibited practice section here, it looks like the requirement currently is just that all patients being treated shall be notified that the respondent is prohibited from practicing, performing, or treating, X. Can the physician or the physician's office provide any sort of notification they want? Does the medical board or staff review the notification they provide? Because you presumably could, sweeten that up to look like we're just simply not performing this anymore, rather than we've been disciplined and are therefore not.
Unfortunately, our probation monitor expert is out of the room, but I believe They do look to ensure that they've provided it, but I don't know if they check the wording of it. But I believe that they do, but I'll have to get back to you on that to give you exactly what they do, what they require the physician to notify them of. If it's just a sign that says I can't do these, and then when that patient, obviously, if the patient were to ask the physician, we don't have any authority over what we can say, of what he can say, except for he has to tell them he can't perform it.
Mm-hmm.
What he says, the reason of why, we don't have that requirement in there.
I guess the difference is it's one thing to say, I'm not performing, these sorts of procedures anymore, and it's another thing to say I'm prohibited from performing them.
And correct me if I'm wrong, many of these cases have, in addition, a part of their probation, a practice monitor. See, the practice monitor gives a report back to the board, so we don't know if that's part of their checklist.
Usually it isn't. This condition is separate than the practice monitor. I don't think the practice monitor looks at this. I do know that, and Ms. Delp can back this up, I do know that our monitors check this and check to make sure that they are providing this notification and that it is in their log that they've provided that notification. I just don't know what the notification looks like.
Okay.
But yeah.
Thank you. Are there any additional comments from the task force? Seeing none, I'll ask if there are any comments from the public present. Yes. If you could identify yourself, thank you.
Sarah Huckle with the Senate Business and Professions Committee. I just wanted to get clarification that even if the disciplinary guidelines were to be updated, there's no guarantee that every physician on probation under the categories would necessarily disclose as a term of their settlement, right? Okay.
I'm sorry, sir. Can you say that?
So even if the disciplinary guidelines are updated, there's no guarantee that every physician on probation would adhere to those terms because it's dependent on what the ultimate resolution is with the AG and everything.
Right. Sorry. If they were amended and it was an optional condition, it would be up to the settlement negotiation to put that into that certain item. Even if it is a standard condition, as you all know, because you see this from time to time, there is always that negotiation during the settlement conferences and settlement on that case.
Okay, thank you. Great question. Are there any additional comments from the public? Yes, please.
Okay, I'm going to be a broken record because I just want to say again and make it clear that we're trying to get the board to create a standard condition that for certain people on probation for certain reasons, serious reasons, have to tell their patients that they're on probation. And I know that we've been told that often is negotiated away, but if you look at the probation orders, you will see that almost all of them have the standard condition that they cannot supervise physicians' assistants. Now, why would that take precedence over telling a female patient that they're on probation because of sexual misconduct, and so they have to have a chaperone in the room with the patient? Why would that take precedent? And that is on almost every single order. I think it might be on every order. That is a standard condition and it's there. And that is not negotiated away. So what we want is something that isn't negotiated away. And I understand how these things work, but it's it's pretty important to have this as a standard and not as an option. If it's an option, it won't be used. And that's what we're asking you to do, is make it a standard under certain circumstances. That patients be notified about their doctor's probationary status. Thank you.
Thank you. Are there additional comments from the public? Seeing none, are there any comments from the phone?
We do have one question from Robert Stewart. Robert, your line is open. One moment.
Robert Stewart.
Robert.
Pardon me? Oh, my name is Robert Stewart. I am private counsel for healthcare professionals all over the United States, particularly physicians and dentists I've been at it for 30 years. And I want to point out that, and probably what you all know, but still, the current procedure for notifying the public of the probationary status of a physician is to list all such matters of current probation or past probation, accusations against the license, settlements of the accusations, conditions of probation, the nature of the misbehavior, and the findings from a trial of an accusation. But every so often in public life, some well-meaning person or organization decides that there are people out there, the public, which need to be protected from some perceived evil. What this often means is to insist that the public be protected even when it has no desire to be. This proposal by Consumers Union is essentially to force the public to be interested because Consumers Union believes that it should be. As it is, any patient has the right and the means to get on the internet a full history of their physician. To compel the physician to notify each patient of the probation believes that it will confuse the patient. It will be read as a suggestion by the physician to their patient of their incompetence to handle the care of the patient. It will provide the patient with far more information, and it's always stated in legalese, which is very difficult even for me to understand, and that patient will never understand it. It is also true that when the medical board places a physician on probation, it has decided after very careful consideration that the physician can safely practice within the framework of certain terms and conditions. Notice from a physician to a patient of the existence of that invites the patient to try to understand what it all means. Does this mean I shouldn't trust my doctor? Is the medical board trying to tell me that my doctor is dangerous? I can tell you of a case I handled of a dentist in Wyoming, and the proposal for settling the case, the doc was a drug addict, street drugs primarily, excuse me, and he was in recovery at the time, and the board there wanted him to put a copy of his probationary order in his waiting room, and wanted him, when he seated a patient in the chair, to give that patient a notice that the patient had to sign that he had read this notice saying, this dentist is on probation and you may want to go somewhere else to get a different opinion or another opinion on whether you need this work or not. This kind of warning and this proof that the patient has read it, signed, and so on is way out of line for any real danger to the patients. The patients know who their physicians are and their dentists, and they can look that up online. So I'm saying that there isn't a need for this change. So thank you for the opportunity to speak to it.
Thank you. Are there any additional comments from the phone?
No additional questions or comments.
All right. Well, I will now move to item 8, future steps. And let me provide you with my initial thoughts. One is we'll have a revised mission statement at tomorrow's meeting that we can present for adoption by the board. In terms of next steps, meetings-wise, I think at least one more meeting is called for now that we've had a good discussion and some information, and there's some Dr. Lewis's committee touches on a lot of this as well. What I'd like to do is get your comments, put together a memo with Kimberly's input on what the sort of next steps could look like, and have that properly agendized at the next our next full board meeting in April, I believe. Is that in April? May. Our next full board meeting in May. So we'll do something like we did for this board meeting. The task force would convene at that time. Those are my initial thoughts, and this report would summarize the comments that were made today and some of my thoughts and recommendations on how we might proceed. Is that agreeable to the task force?
Yes.
Thank you. Do we need a motion for that? No, that's fine. I think that's okay.
Yeah, you can direct staff to work with you.
All right. I'll do that.
Summary.
Oh, all right. Staff will do that. Thank you. Are there comments from the public on this future steps item and how I've just sort of articulated it? Seeing none from those present, are there any comments from the phone?
No questions or comments from the phones.
All right. Thank you very much. Now we'll entertain a motion to adjourn.
I move to adjourn.
Moved, seconded.
Second.
All those in favor say aye.
Aye.
Aye, motion carries. Thank you very much. Thank you, staff, and to the public.